colleagues, although not all not all shadows are here yet, in view of our very tight schedule for this afternoon, I propose that we start. We have 45 minutes for a question and answer session with the EU side of the co-chairs of the transatlantic group of experts on data protection, who are going to inform our committee on the state of play of the discussions with the US authorities. They've met in July, as we know, twice, and they met last week on the 19th and 20th of September in Washington, D.C. Mr. Paul Nemitz is going to speak on behalf of the EU delegation to this working group. After that, we'll open the floor to questions from the rapporteur and the shadows. I will ask you then to answer those questions, and if there's time left, we will invite the other members to put questions to you as well. Mr. Nemitz, you have the floor.
Yes, thank you very much. This was the second meeting of the working group. The first meeting, Chair, you referred to was just an exploratory meeting as to whether such meetings would take place. In this second meeting, the focus on the demand of the US side was on oversight, namely the mechanisms which ensure that secret services in the United States act according to US law. We were introduced to systems of executive oversight. We had in particular a presentation from the privacy officer of the Director of National Intelligence in the White House. The Director of National Intelligence oversees all agencies in the United States dealing with matters of national security. We had an introduction to the congressional oversight, where we met the staffers of the Senate and House Intelligence Oversight Committee, and we also had an introduction to judicial oversight by the Department of Justice. In addition, the US government made it possible that we met with both committee chairmen of the committees which have been tasked by the President Obama to make proposals for reforms of surveillance laws and practices in the United States. One of these bodies is called the PCLOB, the Privacy and Civil Liberties Oversight Board. We met with David Bedine, the chairman. This is a body based on law, which has the task to oversee all anti-terrorism activities in the United States, and a body which will report at a date to be decided, but he said also not too far in the future, on three questions, namely A, are the activities of United States services regarding anti-terrorism legal in light of US law? Second, are the laws according to which they operate constitutional? Third, even if these activities are legal or constitutional and constitutional, is it good policy? And we met also with another body set up by the President, namely a body to come up with proposals for making better use of technology and reconciling national security with fundamental rights and privacy. This body is chaired by Professor Peter Swire. This is not a statutory body, it's an ad hoc body which will report in writing towards the end of the year and orally to the President. We were told on the day of the meeting in 22 days from the meeting, so in 2 weeks. Both groups gave us the impression that there is a certain openness for change. The second, the ad hoc body, also said that explicitly it is part of their mandate to look at foreign policy implications. We have, of course, asked questions relating to, again, also to the scope and impact of activities on EU citizens. but the answers we received this time were limited to answers relating to oversight, namely trying to demonstrate, and I have to say these demonstrations were impressive, that within the US system there's a very tight system of oversight, checks and balances, which make sure to a large extent that the agencies act according to US law. Thank you very much.
Okay, thank you very much. Then I'll first ask the rapporteur, Mr. Moraes, to come in.
Okay, thank you, Chair. We seem to have got more shadows since the presentation began, but thank you to Paul Nimitz for keeping his presentation short so we can ask the questions. And I think you gave the structure of the meeting. So can I perhaps just ask about the substance of what was then discussed to Paul? First of all, the basic question, was there a sense in the meetings of how many European citizens were affected by these activities or allegations? Did you get a sense of how many EU citizens were actually affected directly or indirectly by surveillance activities in the US? A sense of the gravity of the potential effects? Any sense of how metadata was being collected under Section 215? Maybe a simple question, but interesting to know if that was the content of any of these meetings. Secondly, you talked about systems of oversight and so on, and that's important and interesting. But essentially, the nub of this is that there may be activities which are legal, of course, under US law, but as applied to EU citizens, they would be breaching our fundamental rights. And a good example of this would, of course, be the collection of data within the upstream programme on the fibre optic cable networks, potentially very serious breaches there. So is this the kind of discussion you've had in the meetings, the level at which you discussed matters, and if so, please give us more detail or tell us if that was the kind of discussion you had. Perhaps to you and Mr. Priebe, if that's relevant, on the issue of safe harbour, did the transatlantic group discuss a possible review of the existing agreements on safe harbour? Was the safe harbour standard verified in 2000? And it's clear that we need a new legal assessment on this, having regard to the new standards of the Lisbon Treaty, to see how it's compatible, obviously, with EU law. What have been the US reactions to the Commission announcing that they will produce a review by the end of the year? And given the heavy lobbying of US technology companies on the Obama administration to work with the EU to protect the viability of an agreement, have you noticed any willingness on the US to discuss a review of safe harbour? And perhaps that's to you and Mr. Priebe, if relevant. Thank you. Okay, thank you. I don't see Mr. Vos, the shadow of the EPP. He was here before, but he's disappeared. He's coming. Okay, well then we'll skip Mr. Vos. I will also skip myself as a shadow and put myself at the end and give the floor to the Greens.
Thank you very much. And thank you for coming to us again. As I have the impression that on the substance of the surveillance measures and what exactly is behind, there's not so much which we will get at the moment. I concentrate on the questions which is up to what you get out of the meetings, actually. And there, I mean, at the moment, it's obviously again and again the question, is there any chance to do anything, to change anything? And my impression is that some might say there is no chance because there's actually no political mind change in the United States on this. And there I would like to know if this is the case, or if there is actually something going on in the United States with regard to this debate. Also, I have read about now different opinions also about this FISA court to perhaps repeal some of these legal grounds, which I think is the most important for Europeans. And there I would pose my second question, because obviously there seems to be a misunderstanding that we as Europeans only have questions with regard to the legality of those surveillance measures with regard to US law, but not with regard to EU law. And that is, I think, what we somehow need to debate, and where I would like to know what you got out of these meetings, how they understand the difference, which is more important for EU citizens, that even if there could be a lawful surveillance action under US law, it could be a breach to EU citizens' fundamental rights and to EU's fundamental principles. So those are my two questions to you. Thank you very much.
Okay, as Mr. Vos is still not here, Mrs. Ernst.
Thank you very much. Vielen Dank. Also ich glaube, wir sind so an einem...
Thank you, Madam Chairman. I think we're now arriving at the point where we have to ask ourselves a simple question: do we continue with this exercise in shadowboxing or not? Because we're now getting closer, I think, to the substance of this. And at some point we have to ask ourselves the question, can we really have a hearing on this basis? Certainly, as we think back to this morning, a number of doubts are now there, and question marks are now very much in the air. And the question I would ask, is there any point in this? And it's really a question of, it's a simple question about the modus operandi of the group. What documents do you have access to? What things are you privy to? What is the evidence on which you base your judgments? And I just wonder how you prioritize things. What kind of what rules do you use? What criteria do you use in terms of the existing EU legislation? And I'm not at all clear about where you take your marching orders from. Is there any suggestion that surveillance has taken place, and has anyone confessed to that? In other words, is there anything concrete or practical that we can now discuss? Because I want to know the figures. I really do want to get something which stands up in terms of the arithmetic. Otherwise, I think that this is simply a ritual which is pointless.
Mr. Vos.
Auch wenn ich leider die Statements eben nicht mitbekommen habe, aber was mich dennoch interessieren würde, wie...
Thank you very much, Madam Chairman. Can I just ask this question? What guarantees can the US give us in order to dispel any suggestion of industrial espionage? Clearly, the evaluation of data is done by private companies, and how can you rule out industrial espionage?
Do you want to intervene? Not at this stage. Okay, then I'll give myself the floor. Mr. Nemitz, don't take this personally, but I'm deeply sceptical about the usefulness of this whole operation, because first of all, I don't think we're talking about a mere administrative matter that should be handled by a working group of civil servants, no matter how competent and dedicated they are. Secondly, like nearly all the previous speakers, I don't really see how it could be useful for a delegation of the EU to travel to Washington in order to get a lecture about US law and constitution. I mean, we can read that in a book. What we want to know is what happened, and what is relevant to us is if EU law has been violated, but that's our own responsibility and not that of the US government. And then I also, I have a question about judgment. You say they gave you a presentation about oversight mechanisms and you thought they were impressive. But part of this whole operation is based on secret laws applied by secret courts. How on earth Can you qualify that as impressive? If you think that is impressive, I really wonder how you qualify, different kinds of oversight. So I actually think that this whole exercise is largely symbolical. But then I'm a cynic, I suppose. We're out of shadows, unless Mr. Kirkhope has changed his mind. No, he hasn't. Okay, then I'm going to ask Mr. Nemitz to reply, and then we'll come to the other members.
Yes, thank you very much. I will start with the question how the process works. We have, of course, for each meeting a discussion on the agendas. And let's say there is an unwritten rule, which is that in the end, if you cannot agree on the details of an agenda, the host determines the agenda. For this meeting, the US insisted that a focus is given on oversight. From our point of view, and we have made this clear in the run-up to the meeting, it would have been better indeed to focus on the scope and extent of the activity. But we thought it is also useful to look at oversight, because that's part of the fact-finding in any case. The documents which are before us are entirely public domain documents which we research. We do not receive documents from the United States government in any way, and we are not able to discuss detailed program activity in any way, because we are being told all this is classified. We have asked the United States government to give us a guided tour through the declassified judgments of the Foreign Intelligence Court. Unfortunately, this has not been possible this time, but we hope indeed that in the next meeting this will take place, because of course it is important for us to understand the relevance of the activity of this court for EU citizens, and in particular relating to the surveillance activities under Article 702. And our own research has already shown that there is some relevance relating to Article 702, and we will engage again as part of the fact-finding our American colleagues to help us to better understand the relevance of these judgments, as far as these judgments may pertain to elements of protection for EU citizens. Now, as to the first question of Mr. Moares, we have repeatedly in all meetings asked the US government to provide us at least with some yardsticks of how many citizens are affected in the EU and in which way. We have referred to the fact that the United States government has made public a percentage of internet traffic touched on by the NSA. We have drawn the attention to that it should not be technically too difficult, for example, relating to the metadata stored under Article 215, which are telephone connection data, to at least give us a ballpark figure of how many European telephone numbers have been saved under this program of people calling into the United States or being called from the United States. We have also referred to the upstream program and made it very clear that it would be important for us to understand the impact of access to transatlantic cables, as it seems to be happening according to public reports, on EU citizens. Until now, we have not received any indications in this respect. As to confirmation of activities and programs, the metadata bulk collection under Article 215 has been confirmed. It has also been confirmed that Article 702 is the legal basis for the PRISM program. The Article 702 has been explained to us as a targeted program, but the broad collection of everything which goes through the transatlantic cable has been neither confirmed nor denied. Now, indeed, we have indicated to the United States that presentations on oversight are important, but to understand the impact on EU citizens, we have to focus more on what is actually legal under US law, because the main concern is not that people are illegally under US law spying on EU citizens, but we have made it clear that our main concern is as to what is legal. And here, this is something which, we have made clear that we would like to have more clarity on the existence and the impacts, in particular of the activities relating to upstream collection through the transatlantic cable and also to the collection from the servers of the companies directly, in particular, and this we have explained to our American colleagues, in particular because much of the data which goes through the transatlantic cable are actually not international communications with the US, but these are domestic communications. We have explained this repeatedly. If you send an SMS with WhatsApp in Europe from me to you, although this is a purely intra-European communication, the data actually once goes to the backbone in the US. If a citizen in Europe asks a question on the Google search site, this is once going to the US and back to the California computer. So I think these constellations have been discussed, but unfortunately so far we did not get answers. The scope of discussion is fact-finding, and therefore we are presently not engaging in discussions on the reform of the safe harbour. But of course we have drawn to the attention of the government and also of the two review bodies the relevance of the safe harbour decisions in this context, and I think what has clearly transpired is a concern now amplified by what we are hearing about SWIFT, that there should not be a repeated pattern of agreements being made and these agreements then being undermined, potentially undermined by unilateral activity. Mr. Albrecht's question, what is our assessment as to changes? Is there any political impetus for change? Well, also to answer directly then to Mrs. Infeld, of course we are just civil servants and we of course act here under a political authority of the Vice President and the European Commission, together with Member State representatives who have been appointed by Council. The dialogue politically, of course, has been started and takes place between the Vice President and Mr. Holder, and we are just servants. And rest assured that the Vice President herself, she has not only started this, but of course we report to her and she is fully engaged in this activity. Now, as to the feeling, I can only say that the fact that two bodies have been asked by the President to make proposals for potential changes and to assess the situation is some indication that there is an interest at least to look at possible moves, alternatives, options. During our visit we also learned that American industry is more and more outspoken towards the public and towards Congress on the damage these alleged activities of the United States are doing to their business interests globally. So I would say there is a debate ongoing. It is a debate in part about domestic civil liberties issues. That is probably the most important part of the debate. And then there's an emerging debate on international economic impacts. And there are some American stakeholders who are also raising their voice in the interest of people outside the United States whose fundamental rights are affected by these activities. And of course, every time we hear of such people raising their voice, we are very thankful because this group until now is not very big. Indeed, we are studying the opinions of the FISA court which have been published. We have no final view on them, but we are looking forward to a guided tour and explanation of the relevance of the FISA court activity, the direct relevance to EU citizens. Now, as to the question of economic espionage. We have repeatedly received oral guarantees that under US law it would not be legal to carry out economic espionage. This was also part of the statement of President Obama in Sweden. We have, however, not received anything in writing. We have also not received a clear indication where in the law this would be excluded. And as to the guarantees, making sure that private contractors and consulting companies which are competing on the market worldwide, who are also providing services to the US Secret Service community, that they are not using these data for other purposes. We have not been reassured yet with any information about the mechanisms which are foreseen in the United States to make sure that this is not the case. But a note has been taken of our interest to know more about this, and we hope very much that in a future meeting we will be informed on these issues.
Okay, thank you very much. Maybe on the last issue, in reply to the question of Axel Voss, we could ask some other commissioners as well in charge of competition and trade, for example. They might take an interest. I have two requests for the floor. Mrs. Zippel and Mr. Weidenholzer. Nobody else? Mr. Brons, Mrs. Ludford. I think that's it. Mrs. Zippel. If you could all, Mrs. Morvai, please no more than 2 minutes, max.
Thank you. Ich möchte mich auf...
Mrs. Sippel. Thank you very much, Madam Chairman. I'd like to confine my remarks to two subjects. At the last meeting, and Mr. Niemetz has talked about this, the subject was oversight. And he said that the question of scope and the extent of data coverage was the more important subject. Now, of course, it's very laudable to create a body to preserve privacy, but it might be even more important than that to ask the question, are there any mechanisms or any thought being given in the US to this strategic surveillance being restricted, and whether the Council and Commission might give some guidance to the Americans as to how to proceed on the question of what is lawful and what is unlawful. That is very interesting, of course. But I think you can be critical about what is legal in the US. Do we agree? Is this fully in conformity with our own views based on the rule of law in the EU? Then finally, a question on economic espionage. Given the interlinkage between public and private, particularly in the NSA, should we be thinking about new rules? Or given the fact that public and private is so intertwined, should we not solve that problem by disentangling them? And then finally, a question to the Council representative. In the papers we have, we found a reference to the United Kingdom, suggesting, just one sentence if I might, suggesting that there are clear economic interests involved. And my question is this: in the EU, is anything being done to clarify that subject?
Ich schließe mich.
Thank you very much, Madam Chairman. I'd like to pick up where previous speakers have left off. I do not have very much substantive or tangible information. We have got to get this finished by the end of the year. That's just a couple of months away. I think that we're only going to get an overview of the subject without really getting down to the nitty-gritty, because I think that would take longer than we perhaps have. Now, secondly, Mr. Moraes has raised the question of the quantitative side and also the content side of this situation. That's, again, important to know. And then, finally, I think that perhaps there are different approaches to the subject on either side of the pond. The US talks about a certain openness to change, and that, I think, has policy implications, but I think we need more than that. One would like to get something a bit more tangible rather than these bland statements.
Thank you. Mr. Zillis said that the US emphasis was oversight, which meant whether the surveillance was legal, constitutional under US law, and of course a desirable policy. They don't, of course, seem to be concerned with whether it's legal under any other law, whether it's EU, member state or third country law. Perhaps the United States thinks that there really is only one form of law, and that is US law, and that all other laws are simply quaint tribal customs that don't really need to concern them. Part of the problem, of course, is that some of the access gained has been used by using technology to bypass the data passed under this agreement. And that, of course, would be unaffected by any negotiations or by any response from the EU. As Mr. Zillis said, the US has the technology to intercept communications that are not sent to the US. Even if the agreement were to be suspended tomorrow, that wouldn't prevent the US from acting unilaterally. In my view, the greatest hope is a political one of a backlash from US citizens who cannot tolerate the intrusive actions of the National Security Agency, if only because in the end it will be used against them too. Thank you.
Thank you. Mrs. Lutford.
Thank you very much. I'm sorry I didn't hear the first part of Mr. Nemets's comments, but I just wondered if you could tell us whether you've been surprised by the acknowledgement by the US Treasury in their reply to Commissioner Malmstrom. Now, I know you're in the other DG, but I specifically want to ask you in DG Just whether you've been surprised by the US Treasury's acknowledgement that SWIFT data is obtained outside the framework of TFTP, and that is what the reply from Mr. Cohen says. They mention subpoenas. They don't say whether they mean them to SWIFT itself or to individual financial institutions, but they do mention subpoenas. Unsurprisingly, they are silent about whether they are also encompassing NSA upstream interception. But can I ask you, would you regard it as a breach of the SWIFT agreement if there were continuing subpoena requests or subpoenaed orders to obtain supply of SWIFT data? Or, in your view, was SWIFT meant to be all-encompassing and to replace and displace any ancillary subpoenas? And secondly, if there was direct access by intelligent NSA or other intelligence agencies, is that out with the scope of EU law? Is that nothing to do with EU law because EU law does not regulate national security and intelligence agencies?
Thank you.
What is your legal assessment of all of this?
Next speaker, Mrs. Morvai.
Köszönöm szépen. Elnézést kérek, én se hallottam az.
Thank you very much, Madam Chairman. Well, I also missed the early part of proceedings this afternoon because of other things which were going on between 2 o'clock and 3 o'clock, sadly. The EU was expressing criticism of Azerbaijan because they are abusing human rights. Now, there's something a little bit tragicomical about all of this, whereby over lunch, we spend our time doing that, and then afterwards we come back to the afternoon's business. I don't think that we really need all these resumes of American legislation and indeed the findings of all the courts in the United States of America dealing with EU citizens who have been subjected to espionage it seems to me that certainly we need this document as European lawyers. Reading through this, we find very strange things in the papers which we have received today for this meeting. Looking through this, looking at the FISA document, for example, on page 21, it says that when data is collected, the information may be useful to counter terrorism at some stage in the future, and therefore this justifies any collection of information because it may come in handy. Now, perhaps that will wash under American legislation, but it wouldn't stand up in a European court. For example, perhaps if certain kinds of child pornography were acceptable in America, I think we've got to protect children in Europe nonetheless. And my conclusion is that, yes, let's look at the acceptability or the lawfulness of certain things in the US because they've got a particular take on human rights. That doesn't mean that we should slavishly accept their standards. I think that we want to maintain, we want to defend victims.
Yeah, we are publicly elected and therefore we have the right to know what our administrations do. And if America is our friends and the US authorities are our friends, we should have all the information so we can judge. Because I don't think, frankly, that an oral statement from the Americans saying what we are doing is legal is good enough. Because what we know is what they interpret with that. And we can only have that if we have the access to the documents. And this mass surveillance, people don't trust them anymore. So only if we know what they're using the law for, we can judge if it's really legal or if we need to change the law to clarify what's legal or not. And I'll just give one example on that. Regarding trade secrets, they say, oh no, don't worry, it's forbidden. Well, actually, if you read paragraph 1833 of their own Economic Espionage Act, it says this chapter does not prohibit any otherwise lawful activity conducted by the government. So the government is exempted. Anyway, so what value has such an oral statement then?
Thank you. That's exhausted our speakers list, and I'm going to ask Mr. Nemitz to reply, and I'll add in one element. You mentioned that Congress is also, members of Congress are also participating in these sessions. That's a question that we might want an answer to as well.
Yes, on the last question, President, we have met separately in Congress staff members of the intelligence oversight committees of the Senate and the Congress, minority and majority staff, for 1 hour for an exchange of view, but they do not participate in the government-to-government discussions. On Mrs. Sippel's questions on limitations on strategic surveillance without any suspicion, namely the question of the transatlantic cables. Well, the first problem is that we actually do not know more from our conversations with the US in terms of what is actually happening there or not. They neither confirm nor deny taking data from the transatlantic cables. The US government, in our meetings, the Department of Justice is interested in what they call sort of best practice surveillance law, and that's why they very proudly presented to us the impressive number. I think that's what I wanted to refer to, the impressive number. I didn't want to give a qualitative judgment on the oversight mechanism, but the impressive number of oversight bodies which they have in the Department of National Intelligence, in the DOJ, within each of the agencies. They have the FISA courts within Congress. We were told that in Congress there are 30 staff available to the intelligence oversight committees of both houses to carry out oversight, and we received some comparison on the accuracy of which we cannot have not checked to European member states. So there is, let's say, also in an effort, I would say, to deflect the fact-finding activities, always a question back to us. How are you doing it in Europe? Which we normally say, well, that's not subject of our conversation, but, you know, to keep the conversation going, we nevertheless say, well, if you want to see, for example, limitations on surveillance by secret services without any suspicion, please go through the laws of some of our member states, and you will find very good examples, and you will find not so great examples, but you will find examples which limit this type of activity much more severely than they seem to be limited in US law. And we have pointed this out to our colleagues in the US. On the question of private involvement or not, it's a fact-finding mission we're having, so we're having not, let's say, discussions on what would be alternatives and so on, but we are asking for clarifications how the US government makes sure that private data, which may be collected in the context of surveillance activities, is not used by private contractors for other purposes. Mr. Weidenholzer's question on the time frame. The US has offered another meeting in the next weeks, date to be determined. We hope very much we will be able to return to many of the questions you have raised here today, namely a scope of the activities, how many Europeans are actually concerned, what are the limitations of these activities, and why are these Europeans targeted, or why are they subject of bulk collection, for what purposes. We hope also to return to the other side of the coin of proportionality, namely how successful are these programs, where we have also asked a lot of questions and have not received anything beyond what is in the newspapers. After this further meeting, we will have to see what the situation is, but the Commission intends to report in writing before the end of the year. Indeed, I can confirm there are very different understandings of many issues, as the emphasis on oversight for this meeting has shown. There is, I would say, a rather self-referential understanding in the US, namely, the most important question, is it legal under US law? And we were happy to listen this time, but we have made it clear that the concern of European citizens is not mainly whether activities are legal under US law, but the concern is that our citizens, which have fundamental rights because they are Europeans, that their rights are protected, and we have to therefore understand the scope of the activities of the US as far as they may be infringing on rights of Europeans. And I think this message has been made a number of times. Now, as to the questions on TFTP by Mrs. Ludford, I would like to refer this question to Mr. Priebe, who is my colleague from DG Home, Director for Internal Security.
Mr. Chair, thank you. Just very briefly, because the subject has been discussed in detail this morning, let me first add to the information which you have gotten that also in this ad hoc group, of course, we raised our deep concerns about allegations as to side channels besides TFTP, and referred to the ongoing consultation. So, of course, there is a link between this consultation and the broader discussion we are having in the ad hoc group. As Commissioner Malmström said this morning, we have questions in relation to Mr. Cohen's letter, and they are exactly those questions you have raised, and they need to be clarified in the process of consultation. It's impossible to say more at this stage. You cannot expect me to tell you more on an ongoing consultation than Commissioner Malmström told you this morning.
Mr. Priebe, if I may intervene, because I think the question is, if the allegations were true, would that, in your view and your lawyer, would that constitute a breach?
More than that, because Mr. Cohen's letter acknowledges, I won't use the word admits, because it acknowledges freely, assertively, that SWIFT data is obtained outside the context of the TFTP agreement. If that is true, is it a breach? Was it the collective view of the Commission. I specifically wanted to ask Mr Nemitz, actually.
Okay. The question is clear, but whether it's Mr Pliebe or Mr Nemitz to answer, we would like to hear your view. Would that be
Is the
a breach?
TFTP meant to be exclusive?
Okay, it's clear.
I have understood the question, Madam, and you will understand that, as has been said by Commissioner Malmström this morning, this will be subject of further consultations for us, maybe for you.
Sorry, Mr. Pliebe, that was not the question. You did not understand the question. The question was, if somebody breaks into a shop, is that theft? We're asking you for your legal opinion. We're not asking you to say whether or not the allegations are true. But if it is indeed true, if data are retrieved outside the TFTP agreement, in your view, would that be a breach of the agreement? It's a legal issue.
If somebody breaks into a shop, it's a theft. If the Americans have violated the agreement, will be clarified in the ongoing consultations. I can't
okay,
say
so you're
anything
basically not answering the questions.
Yes.
That's a statement. Okay, the Commission is not answering the question. Thank you. Mr. Nemitz, do you want to answer the other questions?
I think the other questions, these were not questions, these were statements, but please let me know if I have forgotten to answer a question. Which one was that?
No, I just clarify what maybe was not perceived as a question. So, regarding economic espionage and so on, what guarantees have the Americans given us that they are not doing it? What procedures do they have that information obtained will not be used for economic espionage?
The answer to this is none. We have received oral assurances, and there is a statement on the record by President Obama that the United States is not doing it, but we have been not further explained how in the law this is excluded, or for that matter, what security systems are in place to make sure that in particular private contractors, who play a very important role in analyzing data which has been collected, do not use them for other purposes.
Thank you very much. That's clear. Thank you, gentlemen, for your presentations and answering the questions, and I think we'll see you again. That brings us to session 3 of today, exchange of views with US civil society, which will be organized as follows. First, we get a short presentation by Mr. Jens Henrik Jeppesen, who is the Director, European Affairs of the Center for Democracy and Technology. He will do a short introduction. Unfortunately, the President of the Center for Democracy and Technology, Mrs. Leslie Harris, cannot be with us today because she had an accident, and we wish her well, obviously. After the introduction by Mr. Jeppesen, Mr. Greg Nojim, I don't know how you pronounce this, will join us by video link. He is Senior Counsel and Director of the Project on Freedom, Security and Technology of the same Center for Democracy and Technology. And then both gentlemen will answer our questions. And we will take questions in the same order as always, starting with the Rapporteur, the Shadows, and then the other members. Welcome, Mr. Jeppesen. You have the floor.
Thank you, Chairman, and thanks for this introduction. We're very pleased to be able to participate in your inquiry, and we commend you for setting up this inquiry in the first place. We understand this is the only such inquiry taking place in Europe at this time. No national parliament seems to have taken such a step. So first about CDT, the Center for Democracy and Technology. We're a civil society organization. We're focused on defending civil liberties and human rights in the digital environment. We are dedicated to keeping the Internet open, innovative and free. Limiting government surveillance has been a priority for CDT since we started. In the US, we helped lead opposition to the Patriot Act and the FISA Amendments Act. We have opposed data retention mandates and proposals to expand government control in the name of cybersecurity. we have organized a major coalition in the US Congress urging politicians to strengthen privacy protections in a key federal law on government surveillance, the Electronic Communications Privacy Act. The document that we have submitted to the LIBE committee for this inquiry includes a review of the protections against surveillance in the US Constitution and laws as they pertain to citizens and non-citizens, and most importantly, the gaps in that protection. Then we provide an analysis of the key surveillance programs that have been revealed, the bulk collection of data under the Patriot Act Section 215 and the collection of information on non-US citizens outside the US under Section 702 of the FISA as amended in 2008. And then we run through the civil society demands for reform of US intelligence surveillance, and finally we have a few observations about the situation in Europe and what are appropriate measures that can be taken internationally in response to these revelations. So, CDC has been working with other civil society groups, companies and advocates, members of US Congress, to get reform of US surveillance programs since June. For various reasons, an enormous proportion of the world's international data traffic flows through the United States. US cloud providers store a large proportion of the world's data in the US, and the US can compel them to grant access under the broad authorities in US law. In addition, the US has developed unique capabilities to conduct surveillance and to draw intelligence from the product of that surveillance. With the level of surveillance capability and access to communications data that the US has come increased responsibilities. It's possible that the NSA has been conducting its programs with the full knowledge and collaboration of European intelligence agencies, but that does not absolve the US government of these responsibilities. They extend to protecting the privacy rights, not just of Americans, but of Europeans and of others worldwide. And our reform agenda reflects this belief. So let me just summarize the proposals that we have been putting forward. First, the Patriot Act should be amended to make it clear that the law does not permit the NSA to collect communications data in bulk. Instead, collection should be limited to records that pertain to terrorists, spies and the like, and to those in direct contact with them. And this would ensure that innocent everyday communications of both US citizens and those outside the US that they communicate with are not swept up in a vast NSA database and to be queried at the NSA's discretion. Second, we need better court oversight of surveillance programs. We need reform of the procedures under which the FISA court authorizes intelligence surveillance so that a voice for privacy and human rights counterbalances the government's surveillance demands. FISA court proceedings are secret, and its authorization of surveillance can rarely be tested in open court. So a special advocate should be appointed to argue the case for liberty. Third, the excessive secrecy that surrounds intelligence surveillance must be lifted, at least in part, while respecting genuine national security concerns. The FISA court's significant legal interpretation should be made available to the public to the extent possible. The government should disclose annually the number of surveillance requests it makes under each surveillance authority, and likewise the number of people whose information was disclosed using that authority. Companies that receive government intelligence surveillance demands should be able to disclose the nature and number of those demands and the impact on their customers. Fourth, the US must acknowledge and protect the human right to privacy enjoyed by Europeans and others outside the US. And so far it hasn't done that, even though the right to privacy of correspondence is enshrined in Article 17 of the International Covenant on Civil and Political Rights. Jurisdictional ambiguities in that treaty and other international human rights instruments cannot justify in-country surveillance that deprives people abroad of their privacy rights. Fifth, US law permits the government to compel companies to assist with NSA surveillance conducted for the purpose of collecting foreign intelligence information, even though the target of surveillance is not a suspected terrorist, spy, or other hostile actor. Foreign intelligence information is so broadly defined that it includes purely political activities, such as a protest at a US military installation or a demonstration against racism. These kinds of activities are related to US foreign affairs and therefore fit within the purpose restriction governing this surveillance. And this must change. The broad purposes for which surveillance can be conducted under the PRISM program should be narrowed to protect privacy and free speech rights of people outside the US. And finally, conducting surveillance through the back door should be outlawed. The US Congress should bar the NSA from circumventing US law by obtaining from other intelligence agencies information that it cannot collect itself. These are the elements of the reform that we have been putting forward and advocating in the US. But it's clear that the problem of pervasive electronic surveillance of citizens is a global one in this era of globalized communication services and networks. Recently, Frank LaRue, UN Special Rapporteur, surveyed the changes in the way communication surveillance is conducted by states and concluded that there was, and I quote, an urgent need to revise national laws regulating these practices in line with human rights standards. The European institutions have an important role to play in this process by helping to define and enforce a set of rules that could be globally influential. In our view, reform is most likely if institutions and stakeholders in the US and Europe work together. As in the US, European governments must assess their own security surveillance practices against human rights principles and must develop a common understanding about how these principles should apply to national security surveillance. And at the same time, Europe should commence a dialogue with the US aimed at seeking a common transatlantic understanding of those rules and oversight structures in both national and trans-border contexts. This approach, if successful, would lift all boats, enhancing protections for both Europeans and Americans and others. And it could set a standard for the rest of the world. The process of reform must begin with transparency. The Snowden leaks have offered some startling disclosures about the nature and extent of systematic surveillance in some EU member states. But we still know far too little about the surveillance laws and practices in the EU overall. So it's difficult to understand and verify to what extent the laws here in Europe measure up against the principles in the European Convention as interpreted by the Court of Human Rights. For the past several years, CDT has been involved in a project researching the laws under which surveillance programs operate in a cross-section of countries. A key finding is that it's very difficult to assess these actual practices because the laws, the relevant laws are at best vague and government interpretations are hidden or classified as they are in the US. European data protection authorities have pointed to these problems, and several MEPs have rightly criticized the almost complete silence from EU member states since the Snowden revelations began. Like in the US, European governments seem very reluctant to open these practices to scrutiny. We realize there is limited scope for action by the institutions as national security remains the sole responsibility of member states. Existing and draft data protection regulation explicitly excludes national security. It's simply not covered. So it's likely that addressing government surveillance only through the regulation or restricting data flows in general with the US will have quite limited impact on the ability of the NSA and its European counterparts to access our personal data. But at the same time, some of the measures that are being discussed are putting economic and political pressure on the US government to advance the reform that we have outlined, and the Parliament needs to keep up this pressure. But fundamentally, we need the US government and we need European governments to commit to a transatlantic process to develop a comprehensive understanding of the criteria that should apply to government surveillance and especially to national security surveillance. In our view, the current state is indefensible. The timing is right to bring greater transparency, proportionality and oversight to these electronic surveillance practices so that we can ensure that human rights principles are respected in both jurisdictions. There is no silver bullet, and this is not a quick fix. This is a long and difficult process, but it is the only principled way to address these concerns. CDT looks forward to working with this committee and all interested parties to advance this process. Thank you.
Thank you very much. Okay, in the meantime, we've been joined by Mr. Greg Nojim. I hope I don't massacre your name. Can you hear us?
Yes, can you hear me?
Excellent. We hear you fine. Welcome and hello to the other side of the pond. We're now going to open the floor for, in an initial round, for questions by the rapporteur and the shadow rapporteurs. Then we'll ask the two of you to answer the questions, and then we'll open the second round of questions. I hope it seems to be working fine with the video link, so please signal if there is any technical problem. First questions by our rapporteur, Mr. Moraes.
Thank you, Chair, and thank you to Jens Henrik Jepsen, massacring your name as well, for your presence here, and thank you for the documents. And this is the first session for civil society. We're going to have other sessions, but it's an opportunity to get a perspective now, a snapshot of what you think of this inquiry and your perceptions. And you opened your statement, I don't know if my colleagues spotted it, but your first sentence was that this is the only substantive inquiry in Europe. There were no national inquiries. In fact, that's incorrect. There have been national parliamentary inquiries across Europe. I don't know how many. Our Secretariat probably has better information on this. But is that, my first question then, is that your perception that the inquiries that have currently happened, for you as a civil society person who's watching the United States and watching Europe, is it your perception that perhaps these inquiries have been not very in-depth, or have been very weak, or very quick? I'm not putting words in your mouth. But has that been your perception? And if you think that, do you believe that, what do you see, if it's not too big a question, as being an outcome of an inquiry like this, which has some obvious limitations? It's going to be dealing with a lot of secondary information. It's going to be dealing with lots of obvious limitations in trying to access information on the PRISM situation, and also intelligence information from member states. So that's my first question. The second question is that you are watching the United States, and we are going there in October. So my question is that we need to know what is happening on the lobbying of Congress. Now, the situation looked in July that the vote in Congress on the lobbying of the NSA, the collection of telephone data in particular, the withdrawal of funding was quite dramatic. And then there was the LIBE bill on FISA and all the rest of it. It seemed to be building up a momentum. And for us as Europeans, whatever our perspective, was that there was a build-up of people looking for accountability on the NSA. My question is was that momentum to do with the issue being important then, or is the momentum running out? The various bills that were bringing accountability to the NSA, is that something that is being maintained in the US, and what lessons do we have for here in the UK? I've got some other questions, but I can see that you're Chair, that you want other people to answer. It's not that there's millions of us, but yeah, okay, I'll come back in the second round, but if you could answer those two questions.
Yeah, okay, I see there is nobody on behalf of the EPP. Mr. Vos is not here, Mrs. Jimenez is not here. I'll skip myself and put myself last on the list. Mr. Albrecht?
Okay, I just dropped in because I couldn't follow your full presentation. I'm sorry about that. But I anyway have a question on the intelligence issues, generally the intelligence structures. Having regard to the intelligence structures of the European Union, do you think it fits into our actual framework and into the integrated form of the European Union of today, that there are intelligence services spying on the citizens or authorities or companies in other member states? And would you see that there are perhaps chances to overcome that by agreeing on common rules or common principles on European level, also with regard to the legal basis, the treaty which doesn't allow for intelligence or national security purposes to regulate, but perhaps you also question that. And do you think that there is somewhere also a legal framework, for example, with regard to the Convention of the Council of Europe, the Convention of Human Rights, of the intelligence in Europe also, and of course in their cooperation also with third states' intelligence services? Thank you.
Mr. Kirkhope.
Thank you, Chairman. Now I know why I don't want to sit in the front row of a cinema, because my neck would end up very quick. But to our guest in the US, particularly good afternoon, or rather good morning. Yep. And to Mr. Jepperson also, welcome. I'd just like to, I've got a question for you, but I just want to make a point on mass surveillance of citizens. Without the electronics, without the incredibly sophisticated technology, the people of the DDR had probably one of the most effective mass surveillance operations under the Stasi for many, many years in the middle of Europe. They didn't have the benefit of technology. And yet, because of the lack of democracy there and other reasons, this was an extremely effective form of surveillance. And I feel myself that the balance between protecting the privacy of citizens, limiting the powers of the state, whilst maintaining security of those citizens, is always going to be a tricky one in democracies. Key question to me is this. As the electronics, as it were, you can call them what you like, the technology, these things move on at an enormous rate. Intelligence gathering, communications generally. Every week or every month we have some new device, some new means of moving information quickly and so on. Is it, in your view, is there a trip point at which it became necessary for us to look at more controls? Was there a certain point? Or isn't this a gradated situation where, as we go forward, and remembering terrorists and criminals also go forward at the same speed in technology terms, but do we have a kind of balanced gradation between the protection of the citizen as the ability to move information and obtain information continues to grow? And that's something which seems to me to be a moving thing, and I'd like your comments on that, please.
Thank you. Mrs. Ernst.
Sorry. Vielen Dank.
Thank you very much. I have two questions from that presentation. Now, I think this is probably the first sensible thing I've heard all day, so it was good that I stayed. Now, you mentioned a reform of the intelligence services, that you said that was quite important. Perhaps you could tell us a bit more about that. Now, obviously, an intelligence service is what it is. So how do we have any form of control? How can that work? How can you have parliamentary oversight? What's the situation in the USA? Is it effective? What would you recommend for this discussion? Thank you.
Self the floor last as shadow for ALDE, but I have I think a fairly simple question to both of you. Do you also look at the aspect of money in terms of budget allocations, how much is allocated? What about the stories about secret budgets? Is there any way of verifying? What about the stories of government actually paying companies, way beyond the coverage of the costs for the collection of data? Do they buy data? What about the financial burden on companies, and how do they feel? I have the feeling that if we got a complete map of the financial dimension of all this, but also who are, in terms of private companies, who are the beneficiaries of these policies, because they're companies specialising in basically snooping is their business, and they earn money with it. Now, I'm a market liberal, so I've got nothing against making money, but we'd like to know, what are the financial aspects of all this. Maybe I can invite Mr. Nojim first to answer any questions he wants to answer, and then we'll come back to you. Is that okay?
Yes.
Yep.
Yep. So I'll start with the first question about the status of reforms in the U.S. Congress. There was a flurry of activity in July, and then it seemed to peter off in August, but that's only because Congress was in recess. Since they returned, there's been a new flurry of activity. Today, while we have this proceeding, the powerful chairman of the Senate Judiciary Committee is speaking at an event at which he's expected to outline his reform agenda for the Foreign Intelligence Surveillance Act. And his staff is working on putting together legislation. He'll be conducting another hearing in early October on reform of FISA. On Thursday of this week, there'll be a hearing at the Senate Intelligence Committee that will be a legislative hearing. So that means there should be a draft bill coming out shortly on reform of FISA. I think it's fair to say that in the U.S., the reforms to the Patriot Act are more advanced and more well developed than are the proposed reforms to the Foreign Intelligence Surveillance Act Amendments Act, the FISA Amendments Act, the legislation under which the PRISM program is conducted. For that set of reforms, I think the legislative agenda is not as well developed. I also think that if members of the parliament there were to ask for the ability to testify at one of these hearings as they come up, it would be difficult for members of Congress to say no. So I think that's an option that you might consider. The other question that I'd like to address is the follow the money question. Where are the financial incentives for the companies that are involved in this? And what is the budget for intelligence surveillance? We didn't know a lot about the budget for intelligence surveillance until the Snowden leaks. In the last few years, the top line number, the total dollars spent on the intelligence community were revealed for the first times. For the longest time, about 40 years, the government said that to reveal even the total amount would help the terrorists. There was recently a disclosure about the budget for intelligence surveillance at a very granular level that was based on the documents that Mr. Snowden released. A lot of money is being spent. Some is going to the companies whose assistance is required by the government for the surveillance. But whether they are actually turning a profit on it, I don't think that that's been made clear. And the numbers I've seen suggest that if it is profitable, it's a small amount. It's not a huge amount given the size of the companies that are involved in the amount of surveillance they are likely being asked to assist with.
Okay, thank you very much. Mr. Jefferson?
Yes, thank you, Chairman. First off, the question about national parliament inquiries. It's good to hear that there is attention and that there is effort in the capitals as well. I think it's safe to say that that effort and that attention has not registered much in Washington. It is not on the radar screen. It may be that some of those Parliament inquiries are restricted in their scope, and that the asymmetry of information is such that it is hard to get to the core of the issues. But I think it is something that we as civil society and you as Parliament, European politicians, that we should help support this if we can. More effort at the national level, because that is where these national security programs are decided on and are operated. On Mr. Albrecht's question about European standards, I think this is exactly right. I think you're spot on in your assumption and your question. It is not. I think it doesn't give comfort to European citizens that the laws and the practices under which our intelligence agencies operate are shrouded in the kind of secrecy that they are. So our proposal is that there should be a European process by which governments try to identify and agree some standards for how we live up, how European intelligence programs respect the principles set out in the Convention. It's a tougher thing how to get there, that's for sure, because I don't know of a way to compel governments to engage in this process. Mr. Kirkhope's question about technology and the evolution of technology, it's an astute observation that it's a gradual process of evolution in technology, and I think what we're seeing, what the NSA revelations demonstrate, is what happens when law and policy and judicial oversight fails to follow this process, to catch up with technology. So I think as we think about solutions to this, one is that there needs to be more updates in terms of the checks and balances that are supposed to be operating within the systems, and that's not happening. And finally, the budget questions. I think Greg has answered those in terms of the financial aspects of the NSA's operations. Is that correct?
Yes, but I think it would be interesting to get a complete map. Sorry? Mrs. Ernst's question.
You were talking, excuse me, I thought I had covered it. You were talking about the control and the safeguards in place. So again, what the NSA revelations have shown is the lack of control, the lack of oversight, the lack of whether judicial, parliamentary oversight. That's what the NSA revelations focus on. That Congress has not been kept up to date. The court has not been able to provide the kind of oversight that it needs to be able to do. And on the European side, we don't know whether the situation is better or worse. I don't think anybody has that information at this point. We're doing research into that, but so far it's extremely hard to come by this information. And that, as I just wanted to stress a point, and that is, that doesn't mean that there's any kind of equivalence between the capabilities and the resources that are available to intelligence agencies in Europe versus the US. Clearly, the US is in a very unique position, and it has a unique responsibility as well. Thank you.
If I could just add to that.
Thank you very much. Now we go to the second round of questions, although we don't... Okay, sorry, I didn't hear you very well. Please, you have the floor.
Thank you. There's a strong belief among civil society in the United States that the mechanisms that have been put in place to control intelligence surveillance, to provide accountability, have failed. They failed miserably. And yet they were strong mechanisms. So we're kind of struggling with what to do about that. Those mechanisms include the intelligence committees, which were created specifically to prevent overbroad surveillance and back in the 70s, political surveillance. They knew about this. They didn't reveal it. And I think that there was a sense on the committees that one day it would come out. Certainly Senator Wyden, one of the leading critics of the Section 215 program, predicted that it would come out and that people would be upset and shocked. And that's exactly what happened. In one case, the Intelligence Committee on the House side did not share them with the rank and file members of Congress so that they could know about the surveillance they were about to reauthorize. I think that's a significant failure on these committees' part. In addition, the FISA court itself, which is charged with approving of surveillance, was often left in the dark about exactly what surveillance activities were being conducted. The government, the NSA, went to the FISA court and said, we will only query, in this case, the database about the telephone call records. We will only query it when we meet a certain standard that is designed to protect privacy. And yet it came out in a subsequent opinion that was recently made public that instead of following that requirement, it was ignored more often than followed. A substantial evasion of court oversight. So we're left with the notion that the only way to rein in the surveillance is to limit it by law and to make clear that the law does not permit the bulk mass surveillance that is now being conducted. Thank you.
Thank you very much. As I said, that brings us to the second round of questions. We're running a little bit late, so I would like to ask everybody to be really concise and stick to 2 minutes max. If you can do it in less, even better. So I have 4 requests for the floor. Mrs. Zippel, Mrs. Gomez, Mr. Weidenholzer, Mr. Brons. Anybody else wants to come in? Mrs. Morvai? Okay, I close the list. Mrs. Zippel.
Thank you. Ich versuche es kurz. Ich glaube,
I'll try to be brief. I think Mr. Jefferson mentioned an important fact in his answer when he referred to these oversight mechanisms, the need to adapt them. I think that's seriously been neglected, especially since the 11th of September. I think if we look at control and oversight, the impression that we have is that commercial interest is at the centre and the issue of citizens' rights is being pushed further and further to the sidelines. So I think the question is, what can we do against this now? What are the possibilities that we have? Now, you talked about resistance to the Patriot Act, to FISA, to others. Now, with regard to the legal basis for surveillance, we need to look at the legal acts themselves. Do you see chances to carry out this type of review, or at least to adapt these systems?
Thank you. Mrs. Gomez?
Yes, I'm reading on Twitter that President Dilma Rousseff of Brazil, just speaking at the UNGA before President Obama, actually pointed out that this use of this surveillance is not only illegal, but it is totally a violation of international law, international rules, and even the sovereignty. So I'd like to ask, if indeed there was this failure of oversight in the US Congress, it was not because the mechanism was not there, as Mr. Jefferson and Mr. Nogem just told us. Was it because there was a failure of integrity, a failure of a political naivete, Machiavellism, cynicism? Because, I mean, that's exactly what the intelligence committees were established for, and they failed. So what can we do if we would ensure that at the national level and even at the European level we would have a similar system, which we don't have? Maybe some national parliaments have, but most of our national parliaments don't have anything similar and doesn't function as well. What could we do to ensure that indeed there would be, they would do what they are tasked to do?
Thank you. Mr. Weidenholzer.
Thank you very much for your presentation. I think the European Parliament does have a particular role here. And this is something we really do need to look at in some detail. I welcome your recommendations to have a joint transatlantic dialogue. I think it's important that we look at this together, these technological developments, also the political and economic aspects, that we can really get a grip on these. So I would be interested to see how you would envisage such a transatlantic dialogue. Who would the actors be? What would the content be? And what role do you think the discussions in Europe on the data protection package could have that we're discussing here at the moment?
Mr. Brons.
Yes. Collection of data, particularly personal data, is always an intrusion, although I have found that I have far fewer secrets than I once had. But of course, we only really feel the effect of that intrusion when intelligence is used other than for the fight against terrorism. The use of data, in some ways, is a much more important question than its mere collection. 2 or 3 weeks ago, I asked Mr. Applebaum whether the information gained was used in purely political struggles, both within states and between states, and he confirmed that it was. Among other things, he cited the, I hope I pronounced this correctly, the COINTEL programme that was concerned with political struggles completely unconcerned with terrorism. He also confirmed that security service misinformation could be used to legitimise international aggression, which is rather a topical issue at the moment. Perhaps a 7th proposal should be added to the previous 6 of Mr. Jefferson's, and that is that intelligence collected should not be used to influence political causes and campaigns within countries or between countries when unconnected with terrorism. Thank you.
Thank you very much. Mrs. Morvai, last speaker.
Köszönöm szépen. Egy kicsit másképp szeretném megfogalmazni.
I would like to tackle this question, perhaps rewording Mr. Bronze's question with regards to data that's been illegally collected. What is this data used for, the data of European citizens? According to what evidence has been gathered so far, it's also been mentioned that perhaps money didn't play that much of a role because companies who were included in this work had were subcontractors, for example, to the American authorities, just received small sums. So there are summaries that have been published. And if we look at the way that the members of the Congress vote, it doesn't really seem to be so much linked to the groups they belong to. It seems it's based rather on the sums they received for their campaigns, and this is financing from these companies that have been involved in surveillance. I think it's important we're not treated as idiots here. It's only because of Snowden that we are aware of all this information. So we need to think now about how the EU will protect its security in the future.
Okay, I'm going to ask you both to reply to these questions. And as we are already overrunning our time, could I ask you to please be concise, because we have another video conference waiting. You have the floor. Mr. Jepson first.
Maybe, Greg, do you want to cover the U.S.
Mike.
Do you want to cover the U.S. points first, and then I'll wrap
I'll
up?
cover them right after you go.
Okay, fine. Okay, so first, commercial interest. It seems from what we know at this point in time, it probably doesn't suggest that there is commercial interest immediately behind the NSA's activities, but it is quite likely that one of the ways to address the NSA's activities will be through commercial impact. I think U.S. internet companies and cloud providers are feeling the pain of the trust that they're losing with customers and consumers globally. About the transatlantic dialogue and getting governments together in the room, it's a good question. I don't think we have the answer at this point in terms of how we motivate and compel governments to have this discussion, but it is...
Congress and Parliament. That was the question, I think.
Congress and Parliament, but I think that that discussion is, I think, going on, correct? I mean, exchanges between... okay. Right. Well, we can only encourage that sort of a debate. Mr. Bruns raised, and the last speaker as well, raised the question about collection and use. Very important issue. And what we are seeing in general as we survey these intelligence programs is that there is what we call a declining wall between national security and other uses, and that information does flow from strict national security anti-terrorism purposes to other public authorities and other purposes. I think I better stop there and see if Greg has any other comments he wants to make.
Okay, thank you. Mr. Nojin?
Thank you. Just a couple. The minimization guidelines that govern the surveillance conducted under the PRISM program provide that with respect to non-U.S. persons, the data that's collected can be used for, quote, any lawful purpose. That means that unless it is specifically prohibited by law, the use is permitted. I think that's overbroad, but I haven't yet heard of a effort in Congress to add a new use limitation that would govern that particular information. We agree that there should not be a financial incentive for companies to conduct surveillance. They should be paid for their costs of doing it when they are compelled to do it, but there shouldn't be a huge markup, because that creates an incentive that runs contrary to one of the structures designed to protect privacy, which is that the company only conducts the surveillance that is demanded of it by the government. So I think that there should be more disclosure about that and some efforts in Congress, the U.S. Congress, to ensure that only costs are covered, that there's not created a financial incentive to engage in surveillance. As for the failure of oversight and why this has happened, I think I could sum it up in one word: transparency. It is lacking. The FISA court, for example, issued some scathing opinions denouncing the conduct of the National Security Agency. But who were those written to? They were secret. They were written to the very intelligence community that was conducting the surveillance that the court was railing against. We definitely need more transparency, and I think that that effort in Congress is farther along than some of the others, and we have some hopes for it. In particular, the notion that the important opinions of this court should be made public.
Okay, thank you very much, both of you, Mr. Jeppesen, Mr. Nojim, for joining us from the other side of the Atlantic. Thank you all. That concludes session 3. We now get to session 4, the effectiveness of surveillance in fighting crime and terrorism in Europe. And we are expecting another video link. I don't know if it works, if it's been set up. Just 1 minute. In the meantime, I'll explain whom we'll be listening to. Mr. Reinhard Kreisel from Vienna, who is the coordinator for the IRIS project, an EU-funded research project. And IRIS means Increasing Resilience in Surveillance Societies. And he will discuss with us the effectiveness of surveillance in fighting crime and terrorism in Europe. And after his presentation, we'll open the floor for questions and answers in the usual order. Mr. Kreisel, we can see you. Welcome to the European Parliament. Can you hear us?
I can hear you. Can you hear me?
Yes, we hear you fine. So welcome to the session of the LIBE Committee in the European Parliament. I'll immediately give you the floor because we've kept you waiting for a bit. And we'll be listening to your presentation first, and then afterwards we'll be putting questions to you, and you'll have the opportunity to answer. Now you have the floor for your introduction, please.
Yeah, thank you very much for giving me the opportunity to talk about our IRIS project. A few words about the IRIS project. It's a FP7 project funded from DG Research, Increasing Resilience in Surveillance Society, and we're looking at the effects of surveillance on democratic societies. Given the short time, as I said in my abstract that I sent to you, I will address 3 questions or 3 problems. Is surveillance a means to combat crime and terrorism or prevent it? What are the effects of surveillance, and can the spread of surveillance be governed in a politically accountable and rational way? The term surveillance societies, to give you a general frame and background, we start from the assumption that we all do live in surveillance societies, which means citizens in these societies are, as we call them, machine-readable social, techno-social hybrids by default. This is the basic status, or you could say the ontological status that we have. And these surveillance societies lend themselves to large-scale surveillance based on electronic data processing technologies. Can surveillance technologies be used to combat and prevent crime and terrorism? These technologies, different technologies, can be used to identify, locate and track individuals. They can also be used for screening purposes, screening populations, flows of goods, information and money. And this, of course, is important for law enforcement. Talking about technologies, the point is not that we look at simple or single individual technologies. The point is rather that we look at assemblages, which means different technologies are combined, and by this they become more intrusive and more threatening to privacy. Now, I think it's important to emphasize that surveillance definitely can help from a law enforcement perspective to prosecute offenders. So once they are identified, which means you could have a kind of a continuum. On the one hand, there is the situation, I have a person, I have a name of the person, and I use surveillance technologies to get all kinds of information about this person. And on the other hand, I have a category, which is more kind of like the marketing thing. I have some general characteristics like being of having a certain ethnic background, having a certain religious persuasion, having a certain, professional background, etc., etc., and I create a category and I start to collect, using in surveillance data to identify individuals that fit into this category. So in between there is the use of surveillance in between these two clear cases. On the one hand, having the individual, on the other hand, having the individual, finding the information fitting with this individual, and on the other hand, having the categories, having general features, and trying to find the individuals. So in between there, that's where law enforcement works. No? As long as I have a reasonable suspicion and say I have a group and I know about this group, there's something I would like to know about them, then surveillance can be of legitimate use. If you take the other end of the continuum, saying you have only general information about suspicious types of person, you're trying to track down these persons, finding individuals, this I think is problematic. So surveillance is powerful to track down a known individual under suspicion or suspicious objects. It's less useful to identify problematic situations or individuals in advance before something has happened. So if I want to know something about person X, Y, Z, it's relatively easy to collect information, drawing on data from surveillance, but then how do I, as a law enforcement agent, decide which individual I want to target? So it's about finding the needle in the haystack, and once I found the needle, then it's easy. But so if you take drones can track a person in a crowd, but a drone cannot decide who the potential predator is in this crowd. The typical situation for law enforcement is to identify potential suspects or to prevent an attack on, say, a vulnerable infrastructure like a public transport system, an airport, or a train network. But these are targets that cannot be protected using surveillance measures. I did myself a study on, I was part of a study group on preventing terrorist attack in urban mass transport systems, and it's quite obvious that no surveillance system can prevent this. So no surveillance camera, no sensor system, no nothing can do anything. And this is, I mean, on an everyday level, this is very simple. If you simply look at the lost and found offices, say in the London Underground, you will find lots of bags that were left there, or all kinds of objects which should be considered as dangerous, basically, but which are simply left there and brought there without any further check or whatever. And also, if you look at police work and investigate cases, it often turns out that it was good old cop work, intuition, and very frequently was chance that led to an arrest. Look at the recent case of the Boston bombers. He was arrested after a citizen reported that something strange was happening in his backyard. No? And if you talk to police practitioners about the use of surveillance, you very often hear that they say, well, in principle it's okay, but we have the problem of data overload. So they get too much information from surveillance technologies or surveillance assemblages, which then cannot be used. There's always still the bottleneck of the human information processing system where all this data has to go through. And at this stage, there's no automatic or automated algorithmic way of identifying, as they call it, uncooperative or suspicious individuals. So the evidence is mixed. On one hand, surveillance can be useful, but only in a very limited way and in some instances. But beyond this, there is no independent evidence that surveillance is any good for law enforcement or for police work or security work. My second point, surveillance, effects of surveillance. I would like to highlight 4 problems here linked to mass surveillance. First, and frequently discussed also in the literature, is the problem of social sorting, which means this is the one end of the continuum I was trying to describe before, which means you simply take a category and try to find people that you fit into this category. So this means you can end up on a no-fly list. You can end up in a situation where you have problems to get access to jobs or having problems to rent an apartment. You don't know why. It's simply because you are located in a certain category based on some kind of data that are collected somewhere about you. So this is a social sorting effect. And also underlying the social sorting effect is a kind of a reversal of the social logic. So the default situation is no longer the law-abiding citizen, but rather the default state is dangerization. So whenever you enter into a transaction or an exchange with an institution or an organization, you have to prove that you're entitled to do so by presenting some sort of machine-readable token or some other token to prove your identity. The typical paradigm of this is the automatic teller machine. You stand in front of it and you have to punch in your code, otherwise you don't get your money. Or you look at the airport, you have to undergo all these procedures to really prove that you are entitled to enter this plane. No? This is the social sorting part. The second frequently discussed effect of mass surveillance has been termed the chilling effect. So it creates the fact that people know or have the feeling that they're on a constant and massive surveillance creates an attitude that has been termed a preventive paranoia, which means that people think somewhere there's a kind of a big brother center watching their behavior and controlling them, which is not always the case, but which as a kind of a public attitude is not uncommon, as we found out in our research. A second point is that mass surveillance can erode the infrastructure of public debate. For example, when journalists are wiretapped, who try to find out something about surveillance practice which they deem illegal or illegitimate, and they become themselves an object of mass surveillance. And this has a kind of a massive effect on open debate, on open deliberation, public discourse, media public. And then, of course, the question is who decides what kind of information has to be considered as classified. So how much can I say? We have the Snowden case now. What is legitimate to bring to the public and what not. So this chilling effect is the second point I would like to mention. The third point, the question is what effect does a mass surveillance or the introduction of mass surveillance have on police work? There's one of the new buzzwords is intelligence-led policing, which means the police should use more, more big data, more surveillance data to organize their work or to do law enforcement work. And when you look at the effects of the use of surveillance on the ground level, which means the day-to-day operation of police, there are a number of adverse effects, which I will not go into detail here, but ethnographic evidence demonstrates this clearly. And also when implementing technological surveillance system, this changes the whole organization of law enforcement. And there was a recent study which was quoted in Financial Times the other day that stated that about 40 to 50% of all these big IT projects tend to crash. They have cost and time overrun and they don't meet the requirements. And I think this is not only the case in private enterprises, but also in the field of law enforcement and police work. And to my knowledge, and we tried to figure out if we could find some studies about that, but there's no independent evaluation of these effects in the field of law enforcement. The fourth and final of the effects of mass surveillance is the breach of privacy regulation. There are, of course, the obvious cases where an individual uses data where he or she has access and uses them for illegal purposes. But then there's a much more important aspect to that breach of privacy regulation, because there have to be legal safeguards and there's data protection rules, but if you really read them carefully, you find that in almost all cases there's a clause opening a kind of a backdoor for permissible limitation to overrun data protection. And here the problem is that often the judge has to rely on a threat assessment that he or she cannot identify or verify independently. And beyond that, there are also these FISA courts in the United States, for example, the secret courts hidden from public scrutiny. So even if there are any legal safeguards, there's always this backdoor where you can circumvent the data protection rules. Third point, very briefly, governing surveillance in a rational and accountable way. A number of problems. One of the key problems from my perspective is that there are two conflicting logics. The one is the logic of the market. If you look at the security research program of the European Union, it says it has two major objectives. The one is to increase the security of the European citizens. The other is to improve the competitiveness of the European security industry. So you have the logic of markets, which it's in itself completely legitimate. But on the other hand, you have the logic of a democratic civil society that is rather focused on protecting the private sphere. So these two logics clash when it comes to the attempts to govern mass surveillance in a political way. Also, there are different players involved with different interests, and again, the problem of legal regulation. Traditionally, law should define the limits of the use of surveillance, but when you look what happens in practice, and this is an example that I encountered the other day in Austria, law is no longer a protective shield against state intrusion. We had the situation here that an APNR technology, an automatic number plate recognition, should be introduced, and there was an interview with the Ministry of Interior, who is responsible for this new, for the introduction of this new technology. And she was asked in the interview, well, isn't there a data protection problem? And she said, well, yes, there may be, but we have to change the law. So that tells you a certain, this is a case for a certain mindset, for a certain attitude towards data protection, towards surveillance. Policymakers and lawmakers also have to rely on a threat assessment produced by law enforcement and security agencies. And there's almost no independent evidence available that demonstrates the effectiveness. So in a way, as I put it in my brief abstract, lawmakers are taken hostage by the security industrial complex, which produces worst-case threat scenarios and offering socio-technical solutions to prevent major accidents. And as I said, when we look at the European Security Research Program, it's primarily about developing new solutions, developing new security solutions, new technologies, but very little research is done on following up on the effects. Questions like, are the technologies applied? If so, what are the effects? Can we prove that there are side effects, or can we prove that these technologies were really proved to be effective? The same is in the field of law. Most security legislation at the national and European level, you don't have a sunset clause say that you say, okay, let's do it for 5 years and then see, was it really worth having this law? Did it really work? I think what basically is missing is a kind of separation of powers, a system of checks and balances in the field of security discourse and security technology deployment. And well, in our project, we're trying to work on this and to improve the situation. Now, I think this was 10 minutes or so.
Okay. Yes, we've actually just overrun the time allocated to this point by a couple of minutes. So if we can conclude here, and I'm going to limit, because I think Claude has already waived his rights to ask a question, so will I, for the sake of sticking to the time limits. I'm looking at the two shadows present. Do you insist on asking a question? I have one other request for the floor, so maybe we could just... I have two requests for the floor. Mr. Voss, do you want to ask a question as a shadow?
Sorry. Ich hatte auf Deutsch oder Englisch?
Deutsch geht auch.
Ja. Ich habe zwei Fragen.
I have two questions. The surveillance, now in your presentation, is that referring also to private companies that are analysing people's behaviour to the smallest detail? And the second question is, do you have the impression that in this world of surveillance, with every technological development, there is the possibility to go even further into the private sphere?
Then Mrs. Ernst as a shadow. Then I have a request for the floor from Mr. Zippel and Mr. Brons. I suggest we close the speakers list. Okay, Mrs. Ernst.
Ja, auch sehr kurz.
Yes, I just want to ask the question about how we can change this logic, how we can move out of this surveillance society, how we can make these changes in the middle and the long term. We want to be able to change the system that we found ourselves in. So the second point, control mechanisms when it comes to surveillance. Perhaps you could say something a bit further. What would really be feasible in parliamentary terms, for example? So where would you see possibilities for the future?
I will restrict myself to only one question. You talked about the danger that open debates will no longer be possible because everything is followed up. So my only question at this moment is, will these effects also have an effect on the very private life of persons? Because if every time I'm going to the internet, to social networks or outside with all the video surveillance, do you believe that even in very private situations people will change their wordings and behaviour if we go on with all these mass surveillance measures?
Thank you, Mr. Brons.
Yes. What proportion of planned terrorist attempts have been prevented as a direct result of surveillance, as distinct from those that were successful from the view of the perpetrators, or secondly were aborted either through the ineptitude of the would-be terrorists or because of the alertness of people on the ground?
Thank you. If you'll allow me, because I did think of a question after all. If you measure the effectiveness of anything, in this case surveillance, you can only measure it if you set it against the stated purpose and the cost. Now, if the purpose is very broad, then how can you measure the effectiveness? And if you don't know what, first of all, the costs are, and secondly, when the stated purpose is fighting terrorism, but you don't get any information from the intelligence community about prevented attacks or how can you measure, how can you make any credible statements about the effectiveness or not? So you have 5 questions, or questions by 5 people. If you could answer them all at once, and then we'll conclude this session.
Okay, I will do this. Let me start from the end. This is precisely the problem, say, how to measure prevention, how to measure a non-event, And this is a debate that's been going on among law enforcement and their critics for quite some time. One point is that there are some cases like CCTV where you could have some independent measurements, but even there the evidence is mixed. We don't have a clear result in terms of effectiveness. In terms of costs, well, costs are in many dimensions. There are costs, like the deployment of the system, the maintenance of the system. There are social costs, there are economic costs, there are political costs, there are psychological costs. We address this in our report quite explicitly and quite comprehensively. But I think all of you are frequent flyers, and simply if you look at the social and psychological cost of getting in a plane these days, you see what it means, what the costs of surveillance are. But effectiveness, of course, is the problem. And deploying or implementing a new surveillance system, a technological system, and I was following this up in a couple of cases. It always turns out, as I said before, it overruns costs, and in most cases it's more expensive than it was planned in the first place. And then, of course, there is the maintenance of these systems. My personal impression is that the main driver for the whole surveillance, the spread of surveillance, is the industry, who simply wants to sell their products or their systems. The proportion of planned attacks that have been prevented, well, this is precisely the point. There is no independent evidence. There is no way to oversee what has happened. In most cases, as you rightly state, attacks don't materialize due to simply to the incompetence of the would-be terrorists. We had a couple of cases in New York, and we had also a couple of cases in Germany where there was bombs were planted that could not explode simply due to the fact that they were built incompetently. But we do not have any evidence on that, and I do not know. There is, of course, let me put it this way: there are data released from law enforcement agencies, but they cannot be challenged because there's no counter evidence. So the law enforcement agencies or security agencies, they have the monopoly of determining the threat assessment. They have the monopoly of evaluating their own performance, and except in cases like that what we have now with the NSA and the Snowden revelations, there's no public debate about this. There should be more public debate about this, and I think at the moment there's a kind of a window of opportunity. Well, the fact that I'm sitting here is a sign that there's a window of opportunity to start this debate and to keep it going. Extending the problem of the limitation of open debate or the preventive paranoia problem to private situations. Yes, we're about to conduct some 300 to 400 interviews, very extensive interviews across Europe, and talk to people about their everyday experience. We don't ask them about surveillance. We ask them about their daily use of technologies and how they run their daily course of life. And in the course of these interviews, of course, we address then problems of surveillance and do they feel observed, do they feel under control. And surveillance is, at this stage, I can say, as far as we've done our interviews, is a pervasive element of everyday life. It's deeply ingrained in our everyday performances, from going shopping to using the internet, and everybody is in one way or the other aware of that, but doesn't phrase this or doesn't see this in terms of data protection or privacy infringement. Now, this is a vocabulary that we use, but the everyday person, let me put it this way, the everyday person feels the effects, is aware of the effects, but doesn't have the conceptual, or if he wants to, in all cases, the political vocabulary or conceptual background to really understand this. Can
I ask you to wind up a little bit, as we have the next speaker already lined up? I'm sorry, but I have to keep an eye on the clock.
Yeah. What can be done to change the logic in parliamentary terms? Good question. I think we had this infamous Index project that was scandalized by the European Parliament, and having a close eye on what happens in the field of research and also in the field of deployment of surveillance technologies, and going to the public and trying to keep the public debate going. I think this is one of the major avenues where we can do something, and a route that the Parliament also should follow. Will technologies develop further? The first question, yes, they will. And there is no such thing as a surveillance technology. There are lots of technologies that can be used for surveillance purposes. And as I said at the beginning of my presentation, we have to look at these assemblages and the way how different technologies, different gadgets, different systems are combined into systems of systems and produce a surveillance effect. So I don't think you can try to regulate technology or technological development. What has to be regulated, or what we have to look at or have to be cautious with, is the way different technologies are used for surveillance purposes. Okay.
Okay, thank you very much, and I apologize for cutting you short, but again, we have a time problem, and I realize as chair that when you have a video link, you cannot discreetly nudge the speaker. I'm very sorry about this. I feel even more brutal than usual. But thank you very much for your time and your presentation and answering our questions. Thank you. So that brings us to the last session of today, session 5, with Mr. Casper Bowden, known to many of you from previous events. Mr. Bowden has prepared a study for the European Parliament, which you find on your desks, with the title "The US Surveillance Programs and Their Impact on EU Citizens' Fundamental Rights." He will give a short introduction to the paper, and then we'll open the floor to... You're not going to give a short... You're going to give a long introduction to your paper.
I'm not going to give an introduction at all. I'm going to assume members have read it.
That's a wild assumption. Okay, Mr. Bowden. Well, maybe, you know, just for the benefit of those of us who've not read it, you know, I have, of course. But just for, you know, the few people who have not read it, you could give a very, very, very short introduction or a summary of, let's say, 2-3 minutes. Some of the main conclusions, you know, some of the topics are well known to some of us, but not to all. And then we'll open the floor to questions and debate.
Well, with permission, I've decided not to take that approach. I did give us many of these issues in February. This report is designed to be self-contained and as concise as possible. So well, the approach I tend to take is more forensic. What I'd like to do is actually go through the text, calling attention to particular issues that I think the committee might wish to pay further attention to, just in case, as it were, when they reflect and read this at leisure, those points go by. There are some quite significant points buried within, and I think that might actually be more productive. Of course, some things will get lost in that approach, but I think that will actually be more efficient use of time than simply trying to restate and recompress what is already there.
Okay, that's fine. Well, you know, the floor is yours, and you decide how you do it. We have about 15 minutes, and then we do question and answer.
Well, first of all, I'd like to say how grateful I am to the Parliament for the opportunity and the Commission to prepare this report. The scope of this report is solely on the activities of the United States and the National Security Agency. There is obviously linkage between the activities of the United States and the National Security Agency and one particular member state, but I haven't explored that in this report. Just a few other preliminary remarks. I know that I'm billed always as the former Chief Privacy Advisor of Microsoft, just to dispel any possible misconception that there is really no alignment between my views and that of Microsoft, if anyone was under that impression. Excuse me. I think that the first observation I'd like to make goes actually as a more general observation to something that Mr. Bronze said earlier, that perhaps there is a view that it's the collection of data is less important than the use. And I think I disagree with that. And the reason I disagree with that, I want to illustrate in this way. Since the Snowden revelations, public opinion now understands that persons of influence in society, politicians, journalists, people in any organisational hierarchy, know that the National Security Agency is likely to know any personal secret which they have committed to an electronic medium, perhaps over the past 10 years. We don't know how long this data is stored. So to jump in at the deep end, I think this creates profoundly dangerous destabilising factors in democracy, because it means that public opinion now has to consider, are the people of influence in society, as it were, looking over their shoulder, thinking, second-guessing, oh, maybe I'd better not write that letter. Maybe I'd better soften my approach. Maybe I'd better not do something which is against the interests of US foreign policy. Because if those secrets, those embarrassments, those points of leverage on persons of influence in society, even if they don't exist, if the public believes they might exist, this is something, a transition, if you like, which has already happened. And I don't think this has been sufficiently factored in because of the scale of the Snowden event. We've never had a disclosure of secrets like the Snowden event. Another general prefatory remark is there are known to be still tens of thousands of documents in the Snowden material which have not been written about and have scarcely been analysed. So it's entirely possible that the subject matter which is written about in this report will be dwarfed, in fact, by subsequent revelations. The approach I've taken in preparing the report was to try and fuse together historical and contextual policy information to give some sense of perspective, with the up-to-the-minute revelations that have been happening over the past 2 months, and to weave those together. So on page 8, the first, I think, theme I'd like to draw to the committee's attention is something very fundamental that's often overlooked. It's in the section marked Privacy Governance, and it's really to do with the way that data protection law works. If one takes a long perspective, then there's something rather odd about data protection law in that it takes away a sort of fundamental power, if you like, from the individual. Once data is submitted to somebody else's system, whether that's a government system or a private sector system, the individual can really no longer object when that data is copied. If that data is copied to 1,000 machines within one organisation, or if that data is copied onto 1,000 different organisations, or into another legal regime. It is an assumption that if the right legal boxes have been ticked, well, the individual just has to put up with that. But it's sort of obvious, and it's true, that every time data is copied from one system to another system, the privacy risk is increasing, strictly increasing. It never decreases, because the risk that something bad will happen to that data and that something bad will happen to the individual as a result of that happening to that data is always going to increase. Now, this is a long-held assumption in data protection law going back 40 years. But I think the Snowden events and the developments in cloud computing particularly, we ought to be asking some rather fundamental questions about the intellectual basis for data protection law. Moving through the report, I'd next just like to dwell on the section on page 13 on X-key score. X-key score is an indexing and searching system. It involves a 3-day rolling buffer of the full take of data stored at 150 global sites on 700 database servers. And it indexes email addresses, file names, IP addresses, port numbers, cookies, webmail and chat usernames, buddy lists, phone numbers and metadata from web browsing sessions, and so forth. So that description is rather flat, but when one dwells on the immensity, the immense power, surveillance power of that capability, it's something that we've never really dreamt of before. It's something Orwell did not foresee. It means that data can literally be plucked out retrospectively in time. It gives the analyst a kind of time machine. So without any prior suspicion about an individual, it's possible to go back and examine the conduct and behaviour of anybody in the world, except, of course, Americans to a limited degree that we'll come on to. So the next point of interest, I think, is about Bull Run on page 14, which is the code name for the NSA program for the last decade, to break into widely used encryption systems, probably not directly by mathematical techniques, but using things like side channel attacks, electronic emanations from the computer through which the key can be reconstructed, and also through perhaps suborning or co-opting manufacturers of security systems and equipment. Now, this has created the most shock amongst the technical security community, and everywhere in the world, analysts and security specialists are now trying to guess and reconstruct which systems may be vulnerable and rekey or upgrade those systems. But they're working in the dark. And from talking to some of the journalists who have had access to this material, I have not, we can't expect there to be very much more specific detail to come out about that. So we have an immediate problem, which is we know a large number of the systems that we thought 3 months ago were secure. We know a large number of those are not secure, but we don't know how to find out which ones. Moving through, the next point of interest, I think, is about foreign intelligence information on page 18. Foreign intelligence information is the core term of art underlying the PRISM programme. It was first defined in the 1978 Foreign Intelligence Surveillance Act, and the part that I'm interested in here has not actually changed since 1978. To get the little italicized text, you have to substitute 2 levels of definition in what is rather a complex formulation. And this, if you like, only represents 1/10 of the full definition of foreign intelligence information. But it is worth dwelling on, and I'll read it in full. It is information with respect to a foreign-based political organisation or foreign territory that relates to or if concerning a US person, is necessary to the conduct of the foreign affairs of the United States. So that is an immensely broad definition. That really means that any data of assistance to US foreign policy is eligible, including expressly political surveillance over ordinary, lawful, democratic activities of citizens in European Union countries. Now, we don't know to what extent that definition is applied, because a curious fact is there has been nothing written at all about that in 40 years. There has been no legal commentary, there has been no published guidance, there is no executive orders elaborating what that means. It is simply unknown what effect that has been put to over the past 40 years. But the supposition is that this would be the power under which purely political surveillance of activities in a foreign country, counter-espionage possibly, but essentially political spying would be conducted. Now, there is in this definition, you will notice, a discrimination by nationality. If this was concerning a United States person, the criteria would be necessity, a very, very strict legal threshold. But if it's not a US person, it merely relates about the weakest legal threshold one can imagine. And when we come on to look at the 702 power, that also contains an express discrimination by nationality. So when you apply the two together, there is what I call a double discrimination by nationality, favouring American citizens and disfavouring everybody else. Now, I don't think there is anything in European law remotely like that. In fact, I haven't included a human rights analysis in this work, but talking to human rights experts, they would regard that as simply and obviously unlawful under the European Convention. There is, in fact, also, I'll just mention this briefly, in Section 215, Greg Nogem was discussing the US trend to focus on trying to reform the Patriot Section 215 power. Well, the reforms that are being discussed in the US actually are going to not help us very much, and they're certainly not going to help us if the part I've called attention to here remains intact, which is that apart from the counter-terrorist justification, there is also this very broad purpose to collect foreign intelligence information not concerning a US person. So that is, if you like, a carte blanche to apply the 215 power to foreigners. So if they restricted the selective collection of information according to the counter-terrorism criteria, but don't fix that, it won't do us any good. I want next to go on to page 21, and when we consider the collection of foreign intelligence information under the PRISM programme, which is based on the Section 702 power, there is the statute to work with, and the statute says that there are minimisation and targeting procedures. And when I wrote my analysis of this power for the report last year in cloud computing, when presented this to LIBE in February, I never expected to see those minimisation and targeting procedures, but indeed they were published unredacted in full by The Guardian on the 20th of June. So when one reads them, what one finds is that there is no limitation whatsoever or no protections whatsoever for non-US persons. It is, frankly, as I had expected and predicted. So this is a very strong confirmation that there are no privacy protective powers or procedures in place for non-Americans. The next point on page 22 is to do with a disclosure that was made just on August 21st, and it was actually a letter written by the US government to the leaders of the Congressional Intelligence Committees, and it has a particular paragraph, which I've quoted there in italics, which is of great significance, I think, to this work, the work of this committee, and has not been commented on elsewhere. Now, what is going on here is after the National Security Agency has filtered the information it collects from the upstream systems and all the other systems we talked about, they apply this attempt to make a 50% probability determination, is this data about Americans? And the data which they think is probably, on that 50% basis, about foreigners, then continues in a kind of pipeline. Now, what this paragraph says is that pipeline can be split. So, for example, the CIA would get its own primary copy of that filtered data to work with and store and analyse and use for its own missions, and indeed other members of the US intelligence community. So if we consider what material Snowden would likely have had access to, it may well be he did not have access to the kind of compartmentalised exploitation guidelines for that CIA mission, for example. But it's highly significant that, if you like, the agencies of the intelligence community can have their own copies of this data and then essentially work with that without restriction, because it has already been filtered for foreignness. The next point I'd like to go on to is page 23, just about the general position with our instruments in data protection, which have tried over the years to prevent this, including safe harbour, BCRs for processors, and of course now for cloud computing. And a general remark I would make, and of course it's central to the whole report, is there are loopholes. It appears to be the case that Commission officials in the past 10 years have knowingly or unknowingly permitted these loopholes in the text. The loopholes are typically involving the phrase national security. Does it mean the national security of member states, or does it mean the national security of the United States? And also, another phrase that crops up is a legally binding request. And a legally binding request in US terms includes the full breadth of that foreign intelligence information, including the political purposes we have studied. So I suggest it will be important to the work of this committee to try and go back to some of the papers of the Commission from 10 or more years ago to actually analyse who made those decisions. Was it in good faith? Was there, as it were, bungling? Was there ineptitude? Was there complicity? And I think we should delve into that. I have said a little bit more, perhaps with less restraint than elsewhere in the report on the bottom, page 24. And if we go on now, please, to some of the recommendations. In making these recommendations, I'm conscious of the Committee of Works have expressed an interest in reinstating Article 42 in particular. But before we get there, I have suggested the idea that things being now as we understand them, European Union citizens are placing their data in jeopardy by using American web services and websites. There is already in the Directive 95/46 a requirement where the basis of processing is consent, for that to be informed consent, informed of all relevant risks. So there is already a power in existence to say that European Union citizens should be informed of the fact that if they use an American web service, their data is going to be subject to political surveillance by the United States. And I believe it would be salutary for a strategic approach for this to be done. It would then make sure that European Union citizens were warned that if any material of political interest in the United States is contained in what they are doing, perhaps they better think twice. But of course it's also designed to have a political effect on, I think, raising awareness and perhaps political solidarity within the European Union. It goes without saying from the rest of the analysis in the report that the main mechanisms we have for export of data are not protective against FISA or Patriot, and so in particular I don't see any case for allowing transfers under model contracts or safe harbour to continue. Of course, disengaging those will be a very, very serious matter and will have to be done in a phased way and in a strategic way. And also, to couple a strategic approach, it's going to be necessary and I think beneficial if we consider how to develop our own serious industrial policy for cloud computing, a so-called European cloud. In dealing with that, when we get the further report on the activities of SIGINT within the European Union, of course some member states are going to be in a problematic position. I'll say no more than that. So if we go on to consider the factors about Article 42, there are some reservations which I would think we should consider on page 28. The CEO of Yahoo recently said that if they had said more about the coercion that they were subject to in respect of 702, she could have gone to jail for espionage charges for in fact up to 10 years on the most obvious charge, and perhaps, depending on interpretation, a penalty of up to 30 years or the death penalty. I'm not suggesting that's likely, I'm just suggesting that's what's in the US law. So against that penalisation, we are going to create a conflict of law with Article 42 where the penalty on the European side would be 2% fine. Now, from my experience working in Microsoft, that is simply not going to work. So my proposal is that we should recognise that if a company fails to comply with the reinstated Article 42, we should make that a very serious criminal offence, at the least. And at the moment, the way the new regulation is structured, there is really complete discretion for member states to set the penalties for that kind of contravention. And I think it would be much better to be more explicit about making an explicit serious criminal offence in the new regulation. Also, the level of fines are going to be very, very inadequate. I've referred to a case which I think I'm familiar with and a lot of other people will be, that Microsoft picked up a $1 billion fine in a competition case a few years ago to do with their monopoly over local area networking. However, the profits that Microsoft made over the decade which that fine took to stick were probably around 20 billion, conservatively. In other words, a 20-to-1 mismatch between a cynical calculation of continuing with that business strategy and the fine they ultimately had to pay. Now, that's why I've recommended that to get a really effective consideration of complying with reinstated Article 42, we probably need to think about raising the fine, at least in that respect of that offence, 10 times to something like 20%. I mean, that may sound extraordinary, but all one can say is some of these companies have such enormous resources and deep business strategies, in my personal experience, that is really have to be considered. Now, the last point I'll make before questions is to say that since we know about Bull Run, the NSA project to subvert cryptographic protection, but we don't know which ones, the scope of Article 42 at the moment would only apply to controllers and processors, but not vendors of security systems or vendors of equipment. So the idea is we could make Article 42 apply to them also. So if they were coerced by the NSA to put in a back door, even if they're not processing personal data, they have got to tell the European regulator that they've had to put in a back door. So we are creating a further conflict of law and further jeopardy and penalties for those companies if they choose to comply with US law rather than European law. So I will leave it there for questions, and I hope those specific points have been helpful for the committee. Thank you.
Thank you very much. We're going to start with our rapporteur, Claude Moraes.
Okay, Mr. Bowden, first of all, thank you. I think you've woken everyone up in this last session. I hope you have. That was excellent. Thank you. We commissioned this report from you, and the reason we did it was that we needed a strategic evaluation of the whole area. This is a complex area. Not everyone is an expert on this area, and we need to do a strategic report at the end of this, which, although, as you admitted, this is a fast-moving situation, where even if we make strategic recommendations and evaluations, we may be superseded. We need to do that at the end. And this is also an inquiry which is fairly short. But to do it, we need to have an overview of the area while we're doing the inquiry. So you've done it in time so that we can do it. So even though colleagues have not read the report, I've forcibly read parts of it. Colleagues can read it as we go along, and it will inform our situation, and it will also mean that we can get up to speed on areas that we may not be up to speed on. So on page 27, you've set out strategic options for the Parliament. Now, we have to end up with a report in this area, and of course that will be a political balance, so I'm not going to preempt anything. But one of the big recommendations, I could ask questions on any part of this. I thought the immediate statement that you made was honest and clear, which I think the whole idea that whatever we're going to commit to the electronic medium is now going to be out there, and it's going to have deep political implications, public life implications, but also for people in every area of life. That information can now be used. So that's very clear. All of these statements are very, very interesting. But let me just get to the nub of the kinds of recommendations that we're going to have to deal with. For example, in cloud computing. Now, if there's a FISA 702 request, for example, you're basically saying in this report that that's going to be taken. So we need to get into European cloud computing. This is what basically you're saying in this report. So the kinds of questions I have for you today, so that we could at least make some progress in these areas, is there any chance of European cloud computing happening? You talk about, and I know in your Twitter feed and all your other discussions and writing, you talk about the Brazilian example where, this is beyond my understanding, but you talk about where the Brazilians are now, and Ana Gomes talked about that earlier, where they're talking about keeping the data within the country, keeping it within the confines of their sovereignty. How is that going to work? And does that contradict what you just said, which is that if that happens, that this is just going to be superseded by some other technology, or is it possible to have that within the confines of sovereignty? I want to ask you about other issues that you raised in the strategic options. You talked about encryption. We've already had evidence from Jacob Appelbaum and other people about the encryption of information. The NSA and GCHQ, of course, want everyone to encrypt their information because that's the trigger for then going into the information. Again, I suppose you contradict everything by saying that's a technological area. I mean, are there any recommendations that you foresee in this report which deals with this whole technological area? Is there anything useful we are going to end up with in this Parliament in the report which deals with these very difficult technological areas that's useful in this kind of field? I'm not going to keep going into these areas, but I want to give a taster of where this report is going to be useful for us, because it deals both with the politics and the technology, and I think we're going to have to end up with a report in January 2014 which can at least inform the next mandate as to the sort of direction we're going to go in terms of the balance between privacy and security, but also dealing with the technology so that this report doesn't become out of date within weeks.
Okay, thanks. Axel Voss.
Vielen Dank. Also zunächst einmal recht herzlichen
Thank you very much indeed. That was very interesting. Now, what you said with regard to the US authorities and the surveillance possibilities, does that also apply for the UK? Could you apply that equally there? And when we're talking about the US and the UK, about possible agreements, I don't think we could say something similar with the case of China or Russia. Have you had experiences there? And then also you made reference to safe harbour and the binding corporate rules. I thought it was quite interesting what you said about Article 42 and the possible penalties there. With safe harbour, we have this agreement with the US and with other countries we don't have such an agreement yet. So I wonder to what extent safe harbour, well, I think we would be willing to see how we could make progress with further agreements that could set standards, perhaps. So I don't know if this could possibly be useful with other countries where we don't have such a system in place. If we look at China, for example, every computer produced in China has this spyware integrated. So you hear these stories.
Skip myself and speak last, Jan Albrecht.
Thank you very much, and thank you for your comprehensive outline of this very interesting study. I think there are quite a lot of things which could be further elaborated. I will concentrate on 3 issues. First is on the whistleblower protection, which you also put in as an important recommendation also to us. This is something, of course, which we also have to discuss, and where I would like to know which would be the real chances to get infringements or unlawful behavior to public awareness, and how could we regulate it in our privacy and data protection framework. That is a question which is still not very concrete in my mind. And the second issue is on the industrial policy for EU cloud, which you also line out on page 27. I think that's something, if we talk about also the possibilities how we can act towards third states, of course there's much policy, much question about what can we do in law or in other issues, but it doesn't change that obviously there is a threat which still will be in place. So is there a chance of a real EU cloud to be set up? Which issues would you see as the most pressing? And then last but not least, the question on the debates on the other side of the Atlantic, which is obviously the most important for us in this regard at the moment. Are there movements which you can see with regard also to the US policy debates, changes possibly where we can already focus on and put pressure on the US side to come forward, because they tend to move, or some of them tend to move. So if that would be the case, that would be very helpful to us as policymakers also in relation to our partners. Thank you very much.
Thank you. Mrs. Ernst?
Vielen Dank. Ich habe folgende Fragen. Zum einen interessiert.
Thank you, Madam Chairman. Questions I'd like to ask. I'm interested in general in law enforcement, penalties, sanctions and so on. Is there any thinking as of yet in the Parliament, internally, in terms of current penalties not being enough? Is there anyone thinking about tightening things up on the penalties side? Is there any prospect quantitatively or qualitatively to bring in more binding rules, as it were, or rules with more teeth? Now, secondly, no restrictions, no holds barred when it's not Americans. The question then is, where do we pitch the cross-border dialogue? Since this is so far-reaching and so such a profound difficulty, if it's such a stark difference depending on whether you're Americans or non-Americans, can you really have a penalty which is going to make any impact? And how can you organise this between partners? And then moving on to the whistleblowers, it says here, you say here, that something should be written into the regulations in terms of protecting whistleblowers. Could you just elaborate on that? And then finally, on a European cloud computing system, I wouldn't claim to be an expert. I don't know how that would look, what it would look like. And if Europe did have a cloud computing system, what would it look like?
Off the floor. First of all, on a European cloud, I mean, that seems to be a kind of contradiction in terms. The whole idea of a cloud is precisely that it's big. You make use of all the potential capacity. And I'm not a big fan of saying we're going to put a fence around Europe, and we don't want to make use of all the new possibilities offered to us by technology. However, I do think that we should develop a counterweight against the American dominance on the market, and make sure that we become more important and more powerful in the clouds. Because frankly, and this is the question I'd like to put to you, even if we had a fence around Europe and we would have 100% European cloud, that would not mean that the data are automatically out of reach of the Americans, because and we've been discussing this many times before, it's not only a technological issue, it's a legal issue. Because any company, let's say that we have a company which is part of a European cloud, but if it has an office, even a broom closet in the US, it is within US jurisdiction, but not only that broom closet, but any activity anywhere else in the world. So, it's not just a physical problem. My second question, in your view, would it be possible for Europe, let's say for the European Commission, with making use of the existing data protection legislation, to solve this problem? I think it would, actually. I think the Commission is being too timid and not making full use of its powers, because I think that current EU legislation, data protection legislation, would not allow for the kind of practices that we see. So we don't actually, I mean, new legislation would be better, would provide better protection, but in your view, would current legislation also help? And my last question is, are you aware of similar or identical laws in EU member states? Because I get the impression, I mean, sometimes when you blame the Americans for doing this, they say, aha, but you do the same. So do we have similar laws in Europe? Thank you. That's what you're here for.
So I'll start with the cloud question, because that's a popular one. I think I have tried possibly to anticipate a lot of the cloud questions we've had on page 32 in those points numbered 1, 2 and 3. And I'm going to sort of read out them because I do think they actually address some of these questions directly. The main, if you like, fact of life about data processed in cloud computing, this is where you have thousands of racks of computers in a warehouse that is actually crunching on data, doing calculations, rather than just using the cloud as a big disk drive just for storing data. Is that you can only process data when it's decrypted. When data is encrypted, it just looks like random gobbledygook, and you can't even do sort of 1 + 1 = 2. So the service provider, the cloud provider, has got to know the key. So even if the data is stored encrypted, when you actually want to do the calculation, the service provider has to have the key to decrypt the data, and then it's put into these great big banks of computers. At that point, it's vulnerable to a 702 order. And there is no way out of this dilemma. Encryption is futile for cloud processing against the NSA. There are some highfalutin kinds of encryption which are literally billions of times too slow to be commercially relevant, and there is no sort of golden prospect in sight in research. None at all. And frankly, companies are rather shamelessly misleading about that in their marketing at the moment. So given that reality, the only defence is to keep that cloud data close, solely within your jurisdiction. Now, I also make the point that even though an EU-based cloud company, in point 3 on page 32, transacting in the US is in theory subject to a 702 order, in political terms this is much less likely, for two reasons. Firstly, the staff and management in that European firm, I think, would be much more likely to complain and to try and seek other ways of tipping off or going to European courts to object, to raise legal issues from the European side. And secondly, European staff are simply just not going to be as threatened by US Espionage Act charges. But on the other hand, you'll have to make a calculation, if you like, about how many feet they got in the US. Now, I won't name the company, but there is one very well-known, possibly the major European company in this sector, and if you read their privacy statement, they say that they send their data to the US, or they reserve the right to do so. So you need to look for a European company that, frankly, is taking a lot of steps to physically isolate the data, but also legally isolate itself. But there is a big categorical difference between those two situations. The other point, I think, in this area generally, is that there is a huge difference in terms of a technical security exposure between, shall we say, handing the data to the Americans on a plate and simply their being able to open a fibre optic tap and get all of this data and search through the mass of it. There's an enormous difference in risk between that situation and having data physically within a European data centre running on free software, which is much more scrutable than proprietary software, and then the NSA having to break in various layers of defence and then figure out how to extract that data physically and get that data back to the NSA. One, is like a pinpoint, pinprick attack. The other is literally handing the data over on a plate. Now, one fear I have is that the new regulation could actually make things worse, because when I've analysed BCRs for processors, they are designed, the Commission's plan was to create an equivalence between those two situations I've just described. So it would be legally equivalent under new regulation to essentially export all this data, hand it to the Americans on a plate, and keep it inside Europe, where it would actually be relatively well defended against pinpoint attacks that you would then have to worry about. But according to the formulation of the new regulation, these situations will be treated as equivalent. And it's just obvious to a layperson, let alone a computer scientist, that these are far from equivalent in risk. So we have to fix that. And I've tried to point out very strongly in this report that the regulation as drafted is fundamentally mistaken and has to be reformed. We have to reconsider, particularly binding corporate rules for processors, in the way it's formulated in the new regulation. Otherwise, we will be actually making ourselves more vulnerable if we carry on as we are. Now, to turn to some of the other questions. Let me just go back here. Perhaps if I start with Mr. Foss's question about the situation with the US and the UK. I wasn't exactly sure what you meant by that, but certainly I haven't had any personal experience of Russia or China in this area. I don't even think perhaps I've looked at the Chinese law or the Russian law. The Russians have actually signed up to Convention 108 recently, in the past 6 months, which is very interesting, but I'm not going to make any further comment about that, if I may. Regarding safe harbour, I think we have to look at safe harbour as being fundamentally broken. I had the opportunity in Washington, I was in Washington yesterday, of also meeting the same review group, Obama's review group, as Mr. Nemitz. And I asked them if they wanted to keep that conversation confidential, and they said no. So I will tell you my impression from meeting that review group. Their verbatim words were that they regard safe harbour as a purely commercial agreement, and they don't see any restriction under safe harbour for accessing that data for the full breadth of national security and foreign intelligence purposes. They see that as being their understanding of the deal. So we have to ask, how is it 13 years ago in Europe we made such a colossal mistake? How is it that we could have been so fundamentally deluded or misled, or what went wrong? We really need to know that so we don't make the same mistake again. So I regard safe harbour as dangerous and unfixable and frankly not a model for anything that we want to do in future. If I go back to Mr. Murray's question about, I think I've already talked about oh, yes. Well, there is this phrase that's now put around, and particularly thinking about the Brazilian situation, of balkanization. Are we going to balkanize the Internet? This also cropped up in the remarks of Mr. Cameron Kerry of the US Department of Commerce in a speech a month ago. I think this is a red herring, to be honest, because when nobody here is talking about a censorship situation, where we're talking about compulsorily restricting the access to data by European citizens, instead, what we're talking about is creating facilities and businesses and services locally in Europe and inviting European Union citizens to use them. There's no compulsion. It's choice. If somebody wants to send their data hanging out there in range of the NSA, no one's talking about stopping that under individual self-determination with informed consent. However, what I would like to see happen is to put a stop to the way in which, whether it's a government organisation or private sector organisation, once they've got your data on the basis of a frankly unintelligible privacy statement, they can decide to send it within range of the NSA without you knowing any more about it. That I think we should put a stop to with a much clearer consent process. But this idea of balkanising, it's a red herring, because the censorship, the great firewall situation, is not what anyone is proposing here. We're simply talking about building up European capacity so that individuals can make more informed choices. Yes, the encryption point, I think is a very severe one, because certainly the ways in which we would think about building defence in depth and using encryption up until 3 months ago, or at least up until the Bull Run revelations, we're in a very parlous condition, because I think the leading security experts still think that the fundamental techniques work. The fundamental cipher algorithms have not been broken. But there was a case which emerged last 2 weeks where the leading vendor of security solutions possibly in the world, RSA Laboratories, it turned out that their leading product for authentication was based on a random number generator, which now we know was nobbled by the National Security Agency. And they came clean and said, don't use our product, don't use the thing which you've actually been promoting for the last 5 or 6 years. So it's very early to try and read the runes, but if there is a trend here, I think there is much more safety and security in free and open source software and increasingly free and open source hardware. It looks as if the greatest risk of compromise and subversion of encryption products has been in mainstream proprietary commercial vendors, where perhaps there's been a little bit too much accommodation and cosy relationships with the National Security Agency. This isn't a panacea, but I mean, if I had to put my money on it, I would say always favour free and open source solutions, and increasingly in hardware. So with that proviso, essentially we need to carry on doing the same sorts of security architecting that we've always been doing, but we just need to be much more suspicious about the products and the particular stacks of software that we're using. And what else have I forgotten? Or shall I maybe we have another round? I'll try and if I have forgotten anyone's point, please come back.
Okay, thank you very much. That brings us to the second round of questions. I have 3 requests for the floor. Mrs. Romero Lopez, Mr. Weidenholzer, Mrs. Morvai. Any other requests? No? Then it will be those 3. Mrs. Romero Lopez.
Gracias, señor.
Thank you, Mr. Bowden, for coming again. If you recall, we met when we presented amendments on the data protection law, and we were trying to take care of some of the problems that the cloud presented regarding obligations of subcontracting, because the service providers have their companies that they contract with, their cloud companies, because we don't really know where they are, if I can call them that way. Is it possible for these cloud companies to also be obliged to fulfill the same regulations as the main contractors? Would that be one way of controlling these cloud companies? Because we don't know to what extent this would be a response or not, or if it's a sufficient response, because it's something that we would have to deal with in Europe as well. We might have a lot of cloud companies as well, but they would have to be covered by the same regulation. Secondly, with respect to Article 42 of the anti-FISA clause, this summer we were hearing a lot about the power of the companies, and even Mrs. Redding mentioned how difficult it is to get the explicit consent. If we have difficulties with this aspect of data protection under explicit consent, well, obviously in Article 42 we're going to have even further difficulties. So my question is, given the current draft of Article 42, is that enough to cover what you're suggesting? That they can't be transferred to third countries unless there is prior authorization of the data providers. And if that were the case, then basically we would have to cancel several agreements, because if that is the case, what we don't have is any sort of authority for data supervision, because the authority created by the law on data protection is not does not have the competence for that. Would this be a possible solution? I mean, that's what I'm aiming for, is to get an answer for that. I'm sorry, but I needed an answer with regard to this clause, which I think is extremely important, because renewing treaties or renegotiating agreements with the US is not going to change the current provisions.
I want to hear the other questions as well. Mr. Weidenholzer.
Ich bin sehr kurz.
Thank you very much, Madam Chairman. Very quickly, this morning earlier on, we heard about the Transatlantic Experts Group and their role and function. And my question is whether your paper has been put to them as well. Have they received it? Now, secondly, it seems there's a new digital divide, this time between America and the rest of the world. And my question to Mr. Bowden is this. Do you think that with our data protection package here, we're going to be able to bridge that divide? And what would you regard as being the big chunks of overcoming such a divide?
Morvai, last question.
Köszönöm szépen. Az előadónk.
Thank you very much, Madam Chairman. I'd like to thank you for this. It's very interesting to talk to people who have worked with Microsoft for many years. One is interested to see whether software which has been developed, do you have to buy software which has been produced locally, or do you have to buy things which have been made by Microsoft for a very stiff price? Because there are various institutions which have put a lot of business Microsoft's way, and where Microsoft, for example, has got exclusive rights for the administration, whether that's the Justice Department or education. When that has been done, when people have bought job lots of Microsoft's things, does this in itself constitute a danger? This privileged link between Microsoft and national intelligence in the US, does this preempt certain things? Does it mean that data is automatically going to be passed on to the US secret services, given that Microsoft has that very distinctive position vis-à-vis governments? If you could just mark our card on that.
That was the last speaker, Mr. Bowden.
Well, I think I'll begin, first of all, with what powers exist under 9546, under the existing regulation. In my view, if we think about safe harbour, individual data protection authorities already have the full power and indeed quite sufficient reason with what's been published and revealed so far to shut down a data flow in any particular country from any particular safe harbour company. They could do that today. Moreover, the Commission also has power and sufficient reason to shut down safe harbour itself. We don't need any further legislation for them to do that. They could do it tomorrow, and I think they should. Similarly, model contracts drafted by the Commission from 2001, they have the power to withdraw and revoke the validity of that today. And again, I think they should do that, because I hope the report has demonstrated why they simply condone unlawful surveillance by a third country's foreign intelligence agency. There's really no doubt about it. So what would that leave? That would leave consent. And this is why I place such emphasis in Article 42 on consent, because if we don't get any other structural agreement with the US, then consent would be all that's left. But if you like, what I'm proposing is a sort of two-fisted strategy, that on the one hand we raise political awareness and we close down the exposure except via fully informed consent, and on the other hand we build up the prospects and the economic opportunities for a European cloud, and this will have a pincer effect on, we hope, US political and also commercial opinion. So, for example, we might see civil liberties organisations and particularly trade bodies, instead of lobbying to wear down and batter down European privacy, we might start to see them, as it were, lobbying the American government for better privacy protection for non-Americans. That's the basic strategic idea. Now, I have to say that we are not being realistic today if we think that in the American public debate, our interests, the interests of Europeans or the rest of the world, is making any impact whatsoever. I have counted the references in very, very close following of the American debate. In the past 10 years, up until about 3 months ago, and I'm not kidding, there was one that I'd actually come across in 10 years of debate in America about the interests of non-Americans. One slight reference in one congressional committee. And then in the past 3 months, there have been 3. There's been one blog commentary by Human Rights Watch, Mr. No-Gem's remarks at the Privacy and Civil Liberties Oversight Board, and another very skilled civil liberties lawyer. Nothing in Congress. So we have a lot of work to do, if you like, to represent our European views, and we have to take that to the United States. We have to have parliamentarians, delegations, civil libertarians showing up in TV studios, participating in the US public debate, because frankly it is still today entirely parochial. Now, point about subcontracting, it's a very technical point, but it's a very important point. If you read, as it were, from the point of view of a company lawyer entering into a cloud processing agreement, where that data is going to go in sub-processing, it's incredibly hard to discern that. And there is a Commission project underway to standardise cloud contracts. I won't say more about that, except that it is a very important element of the total solution, and it is a big area of uncertainty at the moment. But in terms of the total solution, it's just like sort of 10% of the solution we need, but we shouldn't forget it. Where else have we got to go? I've mentioned already that data protection authorities have, in my view, considerable discretion to take further enforcement action already. And I think that reminds me of a point that I wanted to make earlier, which is where have data protection authorities and the European Data Protection Supervisor been in this debate so far? I am critical in the report and saying that they did not act at any stage to heed very clear warnings that I and others have given them, both in the time of Safe Harbour and, of course, subsequently in the last 2 years. They have been bluntly asleep at the wheel, and I'm prepared to back that up. And I think it would be useful for the committee to invite particular data protection authorities to come and give an account of how they've been considering these issues for the past 2 years and to justify their inaction, because they have taken no action and they have had powers to take action. Now, I have, again, not mentioned so far in my recommendations specific ideas for reform of the data protection supervisory arrangements. The idea, perhaps, that there could be a sort of special people's commissioner, perhaps elected, with a special mandate to represent individual interest. And I think, digressing somewhat from the question being put to me, there is a glaring deficiency overall in the technical incompetence of data protection authorities. Out of about 2,000 officials working in data protection authorities across Europe, to my knowledge, there are only a few dozen with any technical knowledge whatsoever. And there is nobody, with the exception of 1 or 2, who have a specific postgraduate qualification in the computer science and engineering of privacy. It's rather as if we had designed an organisation to do aircraft airworthiness inspection, and instead of staffing it with engineers, we'd staffed it with 99% officials, bureaucrats. Nobody would think that's a good idea. Yet that is the situation we have in data protection regulation. So my modest proposal is that we should have a quota. It's a blunt instrument, but I can't think of any other way to do it, where data protection authorities should have to have 25% well-qualified people on their staff with a career track to senior positions. The problem is that serious. It's that broken. And you just have to look at the track record of inaction to see how broken it is. Now, going back to the questions I was asked, the report, have I given it to the Transatlantic Expert Group? I'm afraid not, because I don't know who the Transatlantic Expert Group is. We don't know. The names are not public. I believe Mr. Nemitz has seen a copy of my report, and no doubt he will see that it gets to the other members of the group. But perhaps it's something to be regretted in general, that with this and previous expert groups, we don't know who these people are, and we don't know, as it were, their background and their expertise, and that might be rather a good thing for future. Regarding the question of Microsoft's role in the cloud industry, particularly, and software lock-in, I think is what you were hinting at, yes, it's absolutely true that going back to around 2008, 2009, in a sense, Microsoft's urgency about the cloud, which of course I was working there at the time and I saw real up close, it was very adjacent to my job. The reason Microsoft put such a big emphasis on the cloud is they wanted to migrate their customers to their cloud before the competition, because by migrating their customers to their cloud, they would preserve the standards lock-in from the particular fiddly bits of their software and the licensing terms, which would carry on that business for them and make it hard for customers to switch away. There is no defence of this. There should be much more vigorous policy to stop that kind of standards lock-in, and there's still a lot of naivety and lack of awareness in the competition regulators to prevent the kind of strategy games that are used to preserve lock-in. Another point that I think I should go back to is whistleblowers, which I didn't address in the first round of questions. I think some will recall that back in February, after I gave a presentation, I was asked to produce some recommendations on particularly whistleblowers, and indeed there have been some amendments tabled already, which I guess will be coming up for consideration in October. Those amendments are okay. I did actually propose a stronger package back in February, and I'm proposing strengthening it further still. There is a complication, I believe, in that it is quite hard to guarantee somebody asylum and legal immunity under a data protection law. And it is a pity, I believe, that there's just been a package on asylum which was closed and finalised recently, and that would have been an ideal place to put in explicit whistleblower protections which would help here. All I can say is I think that it will take quite a lot of ingenuity and careful legal study to make sure those whistleblower protections are watertight, because what the point is we cannot rely on future whistleblowers to be as altruistic as Edward Snowden. They may be motivated by a reward. They are going to be likely to be citizens of the United States. They could be persecuted and sought by United States authorities for the rest of their lives, subject to rendition and kidnapping and going through airports and so forth. So they're going to need a big, big paycheck, both to live their lives semi-normally for the rest of their lives after taking that momentous decision. But we have to create a credible deterrent. Only by creating a credible deterrent that a whistleblower might emerge is the United States likely to believe that it's not worth trying to engage in those activities.
Thank you. I believe Mrs. Morvai would like to come back very briefly.
Yeah. I'm so sorry. I'm sure that it was not the translation, but nevertheless, my question was probably misunderstood. So let me rephrase it in English. So my question was whether or not there is a danger that if Microsoft software is used by governments in their, public administration, justice, and so on and so forth, can the NSA, basically to put it very straightforward, spy on that given government through the Microsoft system, through the backdoors that we know about? And because we know about the agreement between Microsoft and NSA, does it mean that if a government uses explicitly Microsoft softwares, is that government vulnerable to spying?
I think the question is clear. Mr. Bowden?
Well, it's a complicated question to answer. I can give you the short answer, which is that I don't trust Microsoft software anymore. I cleaned out all Microsoft software from my own systems over 15 years, and I now run 100% free software. From a government's perspective, yes, I think there is much more reason to worry about Microsoft software than free and open source software, but it's quite a long explanation why. Often the things that people think are backdoors in Microsoft software are not actually the backdoors. The real mechanisms for providing backdoors are much more subtle, but would take longer to explain.
Okay, thank you. That brings us to the end of this session. Thank you very much for sharing all your expertise with us. The last part of this meeting we will dedicate to concluding remarks of the rapporteur. No, the rapporteur.
Yeah, members are going to be, and everyone else is going to be really pleased to know that my concluding remarks are on a Mac computer, which is right over there. So, but I'll manage. Just a couple of things, Chair. Can I just say a couple of things?
You can say anything you like.
Well, just first of all to thank the Casper Bowden and the Mr. Jepson as well, and the colleagues in this last session. I think these kinds of sessions deserved a bigger audience as well, and thank all the members who did come because I think they will inform our report. And they were quite rich in detail, so thank you for that. I do want to say a couple of things about the session this morning to members, because what happened this morning was obviously some sort of critical issues with the Commission. We clearly have not got the answers to the questions on SWIFT in relation to the letter to the Secretary of State. So we will have a follow-up to the Commissioner, so we will have to schedule that. Obviously there were outstanding issues on Europol as well, which I think we will have to also follow up, so that will be written in. The third thing I just want to mention as well is the issue of the Belgacom GCHQ meeting, which will now be on the 3rd of October. I'm deliberately not making political and policy conclusions because that's why we're having the inquiry, so I don't want to be doing that in closing remarks. So those are the three things I just want to mention. I think, yes, I'll just leave it there because if I say anything else, people are going to get really tired and just want to leave. But I think I just want to thank everyone for today's session. It was a very long one. And thanks to everyone involved and those who stayed the course. I think Mr. Braun's asked about the 3rd of October. The 3rd of October meeting is going to be the meeting relating to Belgacom and the allegations of the infiltration of Belgacom by GCHQ. We've invited UK representatives as well as the Belgian data protection supervisor. And that meeting will now take place on the 3rd of October at the request of the shadows and other members.
Mrs. Morvai, is this a point of order? Because we want to close the meeting.
Yes, a point of order too, actually, whether there will be a meeting, an inquiry meeting on the 30th, because that's one question. And the second is whether non-attached elected politicians can take part in the delegation that is going to Washington, because I am one of those and I don't belong to a party, but I would very much like to go. And we talk so much about transparency, so I want to ask this question in a transparent way.
My point is clear. There will be a session, I was going to announce that, on Monday, September 30th in the afternoon, so that's 3 o'clock until 6:30. And there will be, first of all, an exchange of views with US civil society, EPIC and the ACLU to be precise. And the second session will be whistleblowers and their legal protection. So that will be September 30th. As to your second question, that is being determined by the coordinators of the committee. I don't think it's something that we're going to decide here and now, but it's being discussed by the coordinators, and as you're probably aware, there is a lot of debate about the composition of that particular delegation, and your request is not the only one, but it's being discussed. So if
I was just mentioning to the Chair that the draft list of hearings is now in your pack, so you can plan ahead because the draft is now published. Okay. And it will be subject to change only in terms of those requests that are being made by shadows and members, for example on the SWIFT issue, which comes up from time to time.
Okay, thank you very much. If there are no other burning questions, no, then I would like to thank everybody and the interpreters. Jan has a burning question. Very, very quickly, Jan, because we all want to go home.
I keep it very, very quick. It's just a question with regard to the Belgacom case, if there will be representatives by the British government, or
I checked. Antoine, the Secretariat. So I'll stop using first names. To be so familiar, the Secretariat has done reminders today again for the British representatives, which I checked today again, and I'll inform the shadows immediately of progress on that today.
Thanks everybody, thanks to the interpreters, and have a nice evening.